তো অপেক্ষা করছি কার জন্য?
I have the petitioner.
কে আছে আমাদের নাম্বারটা?
Well, I can't help it because of this. The client initially came here. Like we wanted to file the application here. Now this is a matter law relates to Lord CBI and Lord falls within the category of bond. But this could not be filed here. Now thereafter this was sent from here to Lord the principal bench. That I filed the application. The Lordship would kindly see the Lord presentation form. You have also indicated it's a Ponzi matter. Now, Lord, yesterday, Lord, my
The Ponzi matters have been assigned to a particular bench, particular court by the government by notification.
But that was in respect of Lord the trial. So for the anticipatory bail is concerned, Lord, I filed this in principal bench. Now the principal bench has sent this before this circuit.
No, somebody showed me some notification.
That was pertaining, Lord, to the trial.
No, all matters, all matters.
Lord, kindly see.
Go before that court.
I went there.
That court, not the principal bench. I am not talking about principal bench. Yes, this is for the trial. Will bail, anti-bail also go there?
Yes, Lord. All the jurisdictions into the case had already transferred to the Calcutta, Your Lordship. All cases, Your Lordship, in all over West Bengal.
No. I understand that. But this talks about the trial,
But Your Lordships, all the case records.
chit
all
fund
the-
cases.
yes, all the case records and others sent to the jurisdiction. Dinhata, all the case records transferred to the Calcutta.
My
In
understanding
pursuance
is
of the
also
3rd
correct.
January 2023 letters by the.
So what should I do? Tell me.
Lordship,
Please don't waste time on this.
Again, the
Kindly take
principal
it to
bench.
No.
Other-
You're not being fair, Mr.
No,
Ahmed.
Lord.
other
You're not being fair.
Why? So, Lord, this was filed before the principal bench. The
Lordship,
principal bench sent.
maybe on
sent
that
it to
time,
the-
no one can intimate before the court did all
But Lord,
the
may I
these
beseech one thing?
notifications.
Seek a clarification from the Secretariat of the Chief Justice. Yes, do that. This is an application for anticipatory bail.
Sir, may I just indicate one thing? That there is another order passed by my Lord Justice I.B. Mukherjee as his lordship then was in dealing with the blood Ponzi matters, where an order was passed that all the matters, bloody taking cue from the blood Honorable Supreme Court's judgment, where blood the Ponzi matters has been directed to be investigated by the CBI. There is also an order which says that all the Ponzi matters would be heard by additional Chief Judicial Magistrate at Calcutta. So blood, that order is there. But so far the trial is concerned. So for the anticipatory bail, Lord, I am in little Lord, roaming like
An
pendulum.
application for anticipatory bail. So this is connected with the chit fund matters. Stop. Paragraph. Learned. You are for the CBI.
Lordships, for CBI.
Advocate for the CBI produces copy of a notification dated April 4, 2023, issued by the Judicial Department of the Government of West Bengal, whereby the Court of Chief Metropolitan Magistrate or Additional Chief Metropolitan Magistrate, Second Court, Calcutta, has been designated as the court for trial of chit fund cases. Stop. All chit fund cases. Learned CBI counsel says that even applications for bail or anticipatory bail will have to be moved before that court. Paragraph, learned advocate for the petitioner disputes such contention. Stop. Paragraph, I request learned counsel for the parties to seek necessary clarification from the office of the Honorable the Chief Justice and accordingly proceed with the matter.
One line, that is since the application was filed before the principal bench.
Comma,
Yeah.
since the application was filed before the principal bench of the Calcutta High Court. Paragraph, list the matter.
Has to be blood sent before the blood principal bench or blood placed before the
Let this matter, paragraph, let this matter be, let the records of the case be transmitted back to the principal bench.
Plus,
And I'm sorry, blood, since blood, I was, I have filed this.
All right, all right, all right.
Principal bench blood.
Yes. Next.
My lordship, I'm praying for a short password.
Next.
Lordship, I'm praying for a short password.
I for the state.
My lord, this matter, your lordship has already granted anticipatory bail with
After.
regard to the co-accused, my lord, admittedly that no NDPS against the petitioner. Because, my lord, the nothing has been seized, my lord, from the possessions of the.
Same footing, same footing.
Same.
Same footing. The petitioner claims parity, citing an order dated April 2, 2025, passed by this court in CRM A 151 of 2025, whereby a co-accused person by the name of Rejaul Haq was granted anticipatory bail. Stop. The petitioner says that he stands on the same footing as Rejaul Haq. Stop. There was no recovery for him, from him. Paragraph. Learned state advocate, while opposing the prayer, in his usual fairness, does not dispute that this petitioner is similarly circumstanced as the said Rejaul Haq. Paragraph. Hence, on the ground of parity, I allow the prayer of the petitioner. Paragraph accordingly, same condition kore diyo, ja ache.
I'm grateful, your lordship.
Six state.
I storing narcotic gaja in my house. They came to my house and found that there's nothing in my house. No narcotics are there. And thereafter they saw that my minor son carrying one gun and threw in the some place. This is the allegation, my lord. Allegation under section Arms Act. Nothing was seized from my possession, my lord. Saying that, my lord, my minor son carrying a gun, my lord. This is the allegation in the affair, my lord.
Yes, Mr. Bishop.
My lord, scissor list is there. From the backyard of the house of this petitioner, the gun was recovered.
This is concocted story. They're saying that I'm storing Gaza, nothing found. They try to implicate me in NDPS case, my lord.
Why they will try? Why they will
My
implicate you?
minors are carrying gun, my lord. No narcotic substance found and implicated me in false case showing arms found. I'm saying I'm storing Gaza, nothing found.
Improvised country-made firearm.
My lord.
And then my minors are.
And it's life. It's not that it's not. It's used. It can be used, my lord.
Saying that my minors are carrying. In the affair thing.
You have.
Page 9, my lord.
You have.
Yes, how old is your minor son?
Minor son is 8 years old, my lord. Saying that.
Seeing the police is.
My lord, they have created a story and.
8 years son is quite capable, my lord. Police came to the house. Search was going on at that relevant time. Yes, he took the pistol and he had.
This information is totally false, my lord. Nothing false, my lord. Do not found Karma, they indicate me in arms, false arms. I will forward it in investigating agency, my lord.
Plus, there is every possibility of further. His interrogation is custodial interrogation is required, my lord.
This heart, my house, nothing found.
Because who has supplied him and there may be others also involved.
My minors.
No. Serious thing. Issue.
Nothing found.
Gun was found.
Saying that my minor son.
What
carrying,
minor
my
son?
lord.
Investigation is necessary. The petitioner says that he has been falsely implicated. Stop. The police had raided his house, having been informed that there was narcotics stored in his house. Stop. They found no narcotic substance. Stop. Instead, they have lodged this false, they have started this false case saying that a country-made firearm was seized from the backyard of his house. Stop. The petitioner prays for anticipatory bail. Paragraph. Learned state advocate shows me the Caesar list. Stop. It prima facie appears that from the backyard of the petitioner, a country-made firearm having total length of 24 what? Inch, bracket approximately, was recovered. Stop. This is a serious issue. Stop. It may require custodial interrogation. Paragraph. Hence, I am not inclined to grant the petitioner's prayer for anticipatory bail.
Seven. Allegation of murder, my lord, there is no eyewitness, but case is based on pure circumstantial evidence, my lord. There is no connection with the present petitioner. Present petitioner husband was arrested and he was enlarged on bail, my lord. I am the wife of the wife, my lord.
Lord,
Can you see the order?
petitioner's name has been specifically, my lord, mentioned in the FIR. Although, my lord, the
Husband's name? Petitioner's husband's
yes, my
name?
lord. Everyone name has been, my lord, he's a, my lord, vegetable seller. And his body, her body was found in a, my lord, banana garden, my lord, in a decomposed condition.
Yes.
And
How do you connect this petitioner to that crime?
my lord, with regard to, my lord, the name embedded in the FIR.
No,
No,
my
no.
lord. Can you see FIR against unknown misdemeanor? I annex, my lord. Can you see the case?
Page?
My lord, page-
7, formal FIR against page 7 and 8, written from unknown misdemeanor, my lord.
Unknown miscreant.
Fine.
Correct.
My lord, kindly peruse, my lord, the
And petitioner's husband is on bail.
Yes, my lord. Husband was in.
my lord, 161 statement, my lord,
Yes, where? Which page?
page 52.
52.
There is the mother-in-law of the deceased victim.
Absolutely total speculation. আমার সন্দেহ যাদের সঙ্গে সবজি ব্যবসা করতো তারা করেছে।
Speculation.
Total speculation.
But my lord,
She'll cooperate if you need her husband is on.
Cooperate,
Yes, yes, of course. The petitioner says that she has absolutely no connection with the alleged murder of the victim. Stop. Her name has been now. She has been implicated on the basis of speculative statements of witnesses, and in particular, the mother-in-law of the victim. Stop. Her husband was arrested and has been granted bail. Stop. She will cooperate with the investigating officer. Stop. She prays for pre-arrest bail. Paragraph. Learned State Counsel draws my attention to the statements of witnesses recorded under section 161 CRPC. Stop. In particular, he has shown me the statement of one
mother-in-law.
ঝনঝনি. Jhanjhani Rajbanshi, the mother-in-law of the victim lady, stop. She merely says that she has a suspicion that the people with whom the victim had business relationship, the victim having been a vegetable vendor, may have committed the murder. Stop. Paragraph on an overall consideration of the material on record and considering that the petitioner is a lady and a housewife and her husband has been enlarged on bail by this court, by the learned trial court, I am of the view that immediate custodial interrogation of the petitioner may not be necessary so long as she, charge sheet not filed,
No, my lord.
so long as she cooperates with the investigating officer. Kori usual condition যেগুলো
On condition, my lord, she make herself available, my lord, as and when required by the.
ওটা তো থাকি as and when called for. As and when called for. 7 দিনের ভেতর রিপোর্ট করবে প্রথমে এই আজ থেকে তারপরে as and when called for আর ছেলেরা হলে once every fortnight and as and when called for. Boxo. Not today.
I have for the state.
Two wives, two ladies. Allegation of my lord.
Both wives of Pradeep Das. Pradeep Das should first go to jail.
And yes, my lord.
What happened? What was the incident?
That's all. There is strictly issue between wife for plus they assaulted, my lord.
Lordship, kindly peruse this photograph. Causing a severe, inflicting severe injury on the skull.
Where's the injury report?
Page 24.
What do you call in Bengali? Shotin.
Shotin. Cut injury on the skull?
24.
Yes, 24.
No,
Injury report, page 24.
not 24.
24, Lordship. The photograph in page 13. Yellow no. Your color blind.
This is page 24. এটা কি?
Lordship, that page. Double pagination is not correct, that means. Colored page, that colored page.
Oh. Not grievous. Huh. Hey, Joe. The petitioner says that there was a fight between her and the other wife of Pradeep Das. Between her, no, the petitioner says that her husband Pradeep Das has another wife by the name of, who is the de facto?
Anjana.
Anjana Das.
Anjana
Kuiborto. Stop. There was a fight between her and the said Anjana. Stop. In the process, Anjana sustained certain injuries. Stop. This is purely a family matter. Stop. She will cooperate with the investigating officer. Stop. She prays for anticipatory bail. Paragraph. Learned State Counsel shows me the injury report. Stop. The report says that the injury is not grievous. Stop. Paragraph. on an overall assessment of the material on record and considering the nature and circumstances of the alleged offense, comma, I am of the view that offense, and also considering that the petitioner is a lady and a housewife, comma, I am of the view that immediate custodial interrogation of the petitioner may not be necessary so long as she fully cooperates with the investigating officer.
Will make herself available as well called for.
Yes, সে তো আছেই,
Much obliged.
এটা দিয়ে দাও।
बड़ा पद the informant had deposited 36,000 in the company name Pan Card Club Limited. Total 36,000 he had deposited in 36 installment. That company assured the informant that they will double the money with 66 months, about 5.5 years. Thereafter, they have, the company also have issued certificate to that. And that subsequently the amount was doubled in 72,000, and when the informant went to the company to return the money, at that time, the company, the agent of the company, tell them to again refix the money. Then you, after 5 years, again the amount is double. Thereafter, he again refixed the money. Thereafter, but in the year 2021, the amount matured and 1,44,000 have to pay the informant. That is the allegation. And this petitioner is the colleague of the informant. This petitioner is the ex-employee of a NBSTC corporation, and the informant also the ex-employee of the NBSTC corporation. The petitioner is not an agent of the this company. His nephew is the agent. And the only allegation against this petitioner is he assured the informant that you will give the money, don't worry. That is the except this, that nothing is there.
No, if he was not the agent, how could he assure that he will?
But when he did not give the payment, thereafter he went to the petitioner because his nephew is the agent of the said company. At that time, he, don't worry, you return back the money.
So this is 420.
Yes,
It's
sir.
420.
What material you have?
Petitioner is 67 years.
This petitioner introduced his nephew. He is the agent of this company. Thereafter, twice the money was deposited.
Yes, but the petitioner is not an employee of the company.
No.
Yes, not the company.
67 years
Yes,
old, he
He introduced
cooperates.
and he assured that money will be.
Esho. The petitioner says that he has absolutely no role to play in the alleged offense of cheating. Stop. He had introduced the de facto complainant to his nephew, who was an agent of a finance company. Stop. The de facto complainant invested money in that company, and thereafter there was some problem. Stop. The de facto complainant apparently has not got his money back. Stop. Accepting that the petitioner introduced the de facto complainant to the agent who was his nephew, comma, the petitioner has no connection with the alleged offense. Stop. He is not an employee, and he is not and never was an employee of the concerned finance company. Paragraph, Learned State Counsel shows me the material in the case diary. Stop. It does appear that apart from having introduced the de facto complainant to his nephew who worked as an agent of the concerned finance company, comma, the petitioner has no role to play in the alleged offense. Paragraph, on an assessment of the material on record and considering the nature and gravity of the alleged offense, comma, and also, and also considering that the petitioner is about 67
Yes, 67.
years old, comma, I am of the view that immediate custodial interrogation of the petitioner is not necessary so long as he cooperates with the investigating officer.
That should not supplementary, meet with the investigating.
হ্যাঁ তো 7 দিনের ভেতর IO every fortnight and as and when called for.
Keep them.
Yes.
আর বাকিগুলো দিয়ে দিও যাতে থাকে। Next. Pass over.
Lordship, this case was registered under in the year 2014. Whether the WPA has been issued or not against the petitioner, we have to check the status.
Not today.
Monday, Lordship.
But I am not placing this application.
Excellent. Not pressed.
কেন এটা কি হয়েছে?
Granted on petition. Malad, allegation under section 363, 366A, 372 of the Indian Penal Code. But allegation is that, Malad, on 18th of March 2014, Malad, the victim girl was, Malad.
18th of March 2014.
Yes.
Achha.
But the victim girl was, Malad, missing from his house. Thereafter, Malad, the complainant came to know that this petitioner and his husband was, Malad, involved for kidnapping this girl, Malad. Subsequently, the husband of the Malad, this petitioner granted bail by this Honorable High Court. Charge sheet was submitted, and Malad, kindly see my involvement.
Also, can you see the 164 statement of the VG, Lordship? Victim.
How old is the victim girl? Was the victim girl at that time?
Lordship, 1/1/2020, 2002.
2014.
The school certificate, date of birth is 1/1/2020.
So she was 12 years of age.
12 years of age that time.
Yes, that time only I'm asking. Clear implications, sir.
Yes, Lordship.
Clear implication. When were your husband granted bail?
Malad, husband granted bail. Malad,
Charge sheet filed.
charge sheet filed. Malad.
Charge sheet filed, Lordship.
Yes, you are absconding. You are absconding. Go and surrender. No. Very heinous crime. The petitioner says that he has no significant role to play in the alleged offense of kidnapping. Stop. Her husband, comma, who is a co-accused and was arrested, comma, has been enlarged on bail by this court or
By this court.
by this court. Stop. She is prepared to cooperate with the investigating of with the police authorities. Stop. Paragraph. I have the Learned State Council. Learned State Council shows me the material in the case diary, including the statement of the victim girl, recorded under section 164 CRPC. Paragraph. I find that this case is of
14.
14.
14.
Stop. The victim girl was 12 years of age at that time. Stop. She clearly says that this petitioner and her husband kidnapped her and took her to Delhi. Stop there. She was sold to a third party. Stop. Wrong things were done to her. Stop. Paragraph. I therefore see that this petitioner has evaded the police successfully for a long time. Stop. Given the nature and gravity of the alleged offense, comma, even though the petitioner is a lady, comma, I am not inclined to
Grateful.
entertain her prayer for anticipatory bail. Ayesha, nature and gravity ki bolechi, given the nature and gravity offense and the petitioner's prima facie involvement therein.
I am for the statement.
Lordship, I am for the petition, Lordship. Lordship, this is under section 323, 25, 307, Lordship. The case and counter case, Lordship. All the other co-accused granted bail, Lordship, by the lower court, Lordship.
Injury, simple injury, and you give attempted murder.
No, my lord. Injury is simple, but there are reports. The skull was cracked, there were hepatoma, and maybe the intention behind the attack is to commit murder. That is why
All right, all right. All the others are on bail.
Yes, Lordship.
others are not on anticipatory bail.
Charge sheet? Charge sheet?
Yes, submitted absconding charge sheet against this two petitioner, this petitioner.
Mafizul and Majibul. Their names appear in the statements.
Yes,
These,
Yes, all are the brother, both sides are
all brothers in all these.
all brothers. But you have been absconding, why?
This was the group action. Lord.
Two families, Lordship, long standing this group, Lordship. Both are the same brotherhood.
What do you say, Mr. Bishar?
I have
But with the
objection.
investigation, Lordship.
I have objection because the CT scan report, can you see the CT scan report, my lord, at page 7?
You could you said simple injury.
But CT scan report is there, my lord. Maybe the injury is simple, but CT scan report there is hepatoma and head injuries are there.
They cooperate with the investigation, Lordship.
All your other brothers were arrested.
Yes, Lordship. They are arrested and thereafter they are gone.
So you obtained regular bail? Obtained
Cooperate with
regular
the-
bail?
cooperate with the investigation, Lordship.
Investigation is over. What will you cooperate with?
Any stringent-
No, investigation is over. Go and surrender. Go and surrender.
Lordship, any stringent condition, Lordship.
No.
Detention is not necessary. This too, my lord, but.
Then let him go. Let him go. The petitioners say that the incident involves a free fight between family members. Stop. They had no intention to cause any injury to anybody. Stop. They are prepared to cooperate with the investigating officer. Stop. They pray for pre-arrest bail. Paragraph. Learned State Counsel strongly opposes the prayer. Stop. He draws my attention to the injury report
And the CT scan report, my lord.
and the CT scan report. Stop. The injury report describes injury report from the injury report, it appears that the injury is not grievous. However, there appears to be some head injury. Stop. Paragraph on an overall assessment of the nature and gravity of the alleged offense, and seeing that charge sheet has already been filed, comma, I am of the view that immediate custodial detention of the petitioner petitioners may not be necessary so long as they cooperate with the police authorities. Usual conditions.
After the state, your lordships. Yeah, earlier 406, 420. Now, this 16th, 18, earlier 406, 420. Allegation, my lord, there is a power of attorney on behalf of the accused person, and you want to some sale of land to the de facto complainant and you can some money, and thereafter, complainant found that he has no authority to sell of the land. It is put in purely, and therefore he took money.
Complainant purchased the land.
With the agreement. Enter into an agreement, and this petitioner shows that he has a power of attorney holder and he has right to sell out.
I see.
And after that, he took 1 lakh rupees as advance. And subsequently, that time was a Corona time, and entire office and
No,
everything.
these kind of people deserve no sympathy.
Here,
What?
20.
Yes.
Yes, Corona time. And this complaint in year 2024, my lord. And then the agreement.
Complaint is filed for 4 years later.
Actually, he is in, that he is the owner. Subsequently, when they search in the office, BLR office, other.
Charge sheet filed. He'll report to you every fortnight. The learned advocate for the petitioner says that the allegations are civil in nature. Stop. Allegedly, the petitioner made a misrepresentation that he holds power of attorney from the owner of a land to sell the land. Stop. An agreement was accordingly entered into with him by the de facto complainant. Stop. The petitioner took money from the de facto complainant. Stop. Later, it transpired that the petitioner has no authority to sell the land. Stop. Paragraph, the petitioner says that the complaint was lodged 4 years later. Stop. The allegations are false. Stop. He is prepared to cooperate with the police to the fullest extent. Paragraph, learned State Counsel, while opposing the prayer, shows me the material in the case diary. Stop. It does appear that there has been undue delay of 4 years in lodging the complaint. Stop. Further, comma, the allegations are substantially of a civil nature. Stop. Charge sheet has been filed. Stop. Paragraph, in the above facts and circumstances, I am of the view that immediate custodial interrogation of the petitioner may not be necessary so long as he cooperates with the police authorities.
Not answering for this question.
Yes, statement of witnesses,
My lord.
neighbors.
Page 6, 8, 10, and 11, my lord. But kindly see page 20.
6, 8, 10, 11. Hang
Yes.
on.
Yes.
Page.
But page 20, so my lord, though my lord, the injury report is there, my lord, but no injury found. But one thing, my lord, smell of kerosene oil from the clothes are there. Page 20.
She is now staying with her parents. She's staying where? With you? Matrimonial home.
That I can't say, my lord. I have no idea about that.
Complaint laws, matlab. Traffic, no injury.
Petitioner is the principal accused. Petitioner is the principal accused.
Other accused persons?
Or on bail. On bail. In-laws are enjoying bail.
There is nothing, no injury,
No injury, but all the statements.
Statement, matlab, Kaushik knows, matrimonial.
Yes, what to do? You know what happens if we do not grant and he's arrested, the chances of reconciliation goes away.
That is also correct, my lord. That is also correct.
Issue. There's no grievous injury. There's nothing. No injury at
No
all.
injury at all, my lord. Only the
And
smell of kerosene oil is there.
the statements are one of the father, one of the brother. They're interested people.
Yes.
The petitioner says that he is the husband of the victim lady. Stop. There, a small matrimonial dispute has been blown out of proportion. Stop. The injury report would demonstrate that the victim did not sustain any injury. Stop. The medical report, injury report. No. Stop. He is prepared to cooperate with the police. Stop.
But investigation complete.
His wife is now residing in the matrimonial home. Paragraph. Opposing the prayer for anticipatory bail, learned state counsel draws my attention to the statements of witnesses recorded under section 161 CRPC. Stop. I have also seen the medical report. Stop. It discloses no injury. Stop. Investigation is complete. Stop. Charge sheet has been filed. Stop. Paragraph. Given the nature of the alleged offense, nature and gravity of the alleged offense, and considering the material on record, in my opinion, immediate custodial interrogation of the petitioner may not be necessary so long as he cooperates with the police authorities. Accordingly. You're appearing.
Not a good case, we'll pray for time.
You will pray for time.
No, he will pray for
Oh,
time.
I see.
It was not a good case.
One day. Monday is a luckier day for you. Okay. Not today. The case will not improve on Monday. It will remain the same.
Say for next circuit.
Material instruction.
All in advance.
All in advance. Not today, chalo.
Citizen petitioner is the mother in the procedural law. I mean, legal and physical as well. I got a husband arrested now in Calcutta. Mother in law. Is it more than 3 years? Husband arrested now in Calcutta.
Is what material against husband arrested and granted bail?
Some days arrested.
What is the material against mother-in-law? Show me.
This is the 164 statement, Lordship, and 3 injury reports are there,
164 of the victim.
victim, Lordship.
The victim is very, very clear. Go obtain regular bail if you can. No. No. All matrimonial disputes can't be condoned. Twice miscarriage was caused by the husband. Yes. Yes, and the
Yes,
injury.
Yes, Lordship.
Page.
Page 10, Lordship. Page 10. Spontaneous abortion. Page 10, Lordship.
And it's the allegation of medical.
And
And Lordship, page 55 and 80.
80.
Page 55 and 80, Lordship. Though the Lordship injuries are simple, Lordship, but due to the torture, Lordship, her pregnancy got aborted.
Charge sheet.
No, Lordship.
She'll cooperate. 67, 62. Eshu. The petitioner says that the petitioner is the mother-in-law of the victim lady. Stop. She says that she has been falsely implicated. Stop. Things have been blown out of proportion. Stop. She is fully prepared to cooperate with the investigating officer. Stop. Her son, being the husband of the victim, has been taken into custody. Stop. He is the prime accused. Stop. She prays for anticipatory bail. Paragraph. Learned State Counsel draws my attention to the statement of the victim lady recorded under section 164 CRPC. Stop. She implicates both her husband. She implicates her husband as well as the in-laws, including the petitioner. Stop. However, the main allegation is against her husband. Stop. I've also seen the injury report. Stop. The victim did not sustain any major injury. Stop. Although one medical report says there was spontaneous abortion, comma, there could be several causes for the same. Paragraph, considering the material on record, comma, the age of the petitioner, if you on record, comma, the fact that the petitioner is a lady aged about 62, you said, 62 years, and she is a housewife, and also that the prime accused is in custody, comma, I am of the opinion that immediate custodial interrogation of the petitioner may not be necessary so long as she cooperates with the investigating officer. 7 দিনের ভেতর রিপোর্ট করবে, and then as and when called for, ইনি মহিলা তো fortnightly দেবে না, as and when called for by the investigating officer. 20.
Thank you, one.
I'm for the statement.
And for the petition question. But here's our petition under section 3, all the petitioners are innocent criminal. In this case, previous enemy in between the both enemies since long. Rather enemy, the particular thought.
326, what is
Different story, Lordship. Adding section 306, abetment of suicide, Lordship. I'm coming.
Case the counter के counter here, kindly see that we face on a seat behind. One of the presentation or two, all throughout the complaint, against the present complainant and his family member. There is case and complaint of false allegation against the petitioner. And you see, Lordship, page number 60.
The 16.
The counter is in this case, the petitioner, wife of the petitioner who also was the complaint against the present complainant and his family member. In this
What is the name of the present complainant?
present complaint name will Lordship,
Ujjola Das.
Ujjola Das. And the wife of the petitioner two, namely Arutiwala Barman, was also lost the complaint. And also I also find the medical documents that the present petitioner Pramodjit Pramod was also received serious.
When was the present complaint lodged?
25 February 25.
And
25th February.
25th February.
Your is 26th.
26, but the incident was occurred in the same date and same time, Your Lordship.
Incident took place 23rd February. Actually, what happened last week, when the de facto complainant's son went to the bath in the river, all the accused petitioner are the FIR name. They are present there in the river side. They are assaulted, abusing slang language to the deceased and
Deceased.
disease, Lordship. Disease. He did due to poison. PM report is collected. Investigation is still progress, Lordship. Due to slang language and assaulted, he consumed poison.
No, what is the charge?
That's 306, Lordship.
Aiding and
Adding
abetting.
section. Abetment of suicide, Lordship. Investigation is still is progressing and PM report, Lordship. PM report poisoning, Lordship. Antibody minute.
That the victim took poison of his
This is the
own.
postmortem report,
We have
Lordship.
no told about the alleged incident. And we have not abated the victim who took poison.
Who is the victim? Victim is your family member.
Victim is a Rupam Das, Lordship, 24 years.
Both I think, quite true. Both are neighbors. You know.
23rd, he admitted
So
in the
the
hospital
victim-
and 26th, he dead.
So the victim was one of the accused in the case lodged by a counter case.
This is different, Lordship, but he
FNM number
He
one,
did us.
counter case, the victim is the FNM number one. We have no rule about the alleged incident. We not abated the victim who took poison.
Charge sheet.
investigation is still pending,
Yes,
Lordship.
yes, where will they go? They'll go and report to you. They'll cooperate with you.
Who will cooperate with the investigation as well?
Sir, anyway, 306 is a weak charge. It's very difficult to establish 306. The petitioners say that the present case arises out of enmity between two families, stop. The alleged incident is of February 23, 2025, stop. The present complaint was lodged on February 25, 2025, stop. The petitioner's wife lodged a complaint on February 26, 2025 against the de facto complainant of this case and her family members. Stop. The victim is the accused number one in the counter case filed by the petitioner's wife. Stop. The petitioners have no role to play in consumption of poison by the victim causing her death. Victim, causing her death. Stop. They are fully prepared to cooperate with the investigating officer. Paragraph. Learned State Counsel says that investigation is in progress. Stop. He shows me the post-mortem report. Stop. The report is to the effect that death was due to the effects of poison, antemortem in nature. Stop. Paragraph. It is not that the victim was a member of the family of the petitioners. Stop. I do not express any opinion on the merits. Stop. Paragraph. On an overall assessment of the material on record and the possible extent of complicity of the petitioners in the alleged offense, I am of the view that immediate custodial interrogation of the petitioners may not be necessary so long as they fully cooperate with the investigating officer. Pure accordingly kore diyo. Tinte. Oh, wife of this Ujjwala Dash is wife of which petitioner? Ujjwala Dash, wife of. Oh, sorry, Aruti Bala Burman is the wife of petitioner Deben Burman. এটা দিয়ে দাও। আছে তো?
I am for the state university.
Again, a very bad case, not today. Determination will not change on Monday. I'll be there.
23 Lordship paying for 1 day, Lordship, Monday.
23, not today. No injury. Yes, Mr. Chakraborty.
Charge sheet has been submitted on 31st of August 2009. Explosive act is there.
But
So,
political. So it would appear if normally when explosive act is involved, it is political. Issue. No injury, no injury.
Injury report is not.
The petitioners say that the incident was an outfall of political rivalry. Stop. Nobody was injured. Stop. Charge sheet has been submitted upon completion of investigation. Stop. They are fully prepared to cooperate with the police authorities. Stop. Paragraph. Learned State Counsel, comma, while opposing the prayer for anticipatory bail, comma, draws my attention to the material in the case diary, including statements of witnesses recorded under 161,
161.
section 161 CRPC.
There are, my lord, in 161, there are witnesses have stated that there was some blast of bombs, my lord. So blasting of bombs are there.
So there are omnibus allegations of blasting of bombs in the statements. Stop. There is no injury report. Stop. Paragraph. Considering the nature and gravity of the offense and the fact that charge sheet has already been submitted, comma, we are inclined to allow the prayer, the petitioner's prayer, essay for apostrophe, for anticipatory bail, so long as they cooperate with the police authorities. আচ্ছা, charge sheet হয়ে গেলে কোথাকার ওসি? Mr. Chakraborty, tell me one thing. When charge sheet has been already submitted, investigation is complete. Now, one of my directions where charge sheet has not been submitted is to report to the IEO within 7 days and then every fortnight
My lord,
and as and when called for.
my lord.
Where charge sheet has already been submitted, to whom should he report?
Should not leave the jurisdiction of the
I
jurisdictional
want
court.
him to report to some either trial court
He can report to the officer in charge
of
of the concerned police station,
his local police station.
my lord.
তারা যেখানে থাকে ওদের
Or where
বাড়ি।
the case has been registered
সেখানে তাই করে দেবে।
of the concerned police station, where he. the
Don't
case
say
has-
concern. Concern creates a lot of confusion.
a specific name.
ওটা যেখানে রেজিস্টার্ড হয়েছে দেখে নাও। হ্যাঁ,
Five. What offense order section is five, 468, 471, 472, 34 of the Indian Penal Code, and subsequently added section 376, 323, 506 of the Indian Penal Code.
service.
So Vimal Banerjee is appearing on behalf of the respective document.
Yes, he appeared, correct. He appeared. Where is he? Pass over, find him.
Twenty-six, no city lordship, Monday.
Statement alleged, supported to 51. That's not law. 26.
Boxo. 376. Your attempt has failed. You couldn't, sir. Learned advocate for the petitioner says that attempted service of this petition for anticipatory bail on the de facto complainant oblique victim, comma, has failed. Stop. Paragraph. Let the state effect service and file. Let the state effect service and file service report on the next date. Paragraph lists the matter once again on April 8.
Twenty-seven.
Why not today, Mr. Patel? Why finish it off?
Twenty-eight.
Time for the state.
The petition has been named blood in the previous case, but the petition was decided to remember something created by medical certificate. This is basically blood poetry statement blood. And I have since blood, I have a medical shock, they have taken my name. My license is valid till 2020. But the person, I'm not even the consigned. And the person from whom possession blood the container blood, sensitive blood, cough syrup, that extract, its fat blood was recovered, they have been granted bail by this court. This way, I have supplied this special certificate of medical license also. That's it.
This is all you have against him?
Yes, my lord, only.
This is six, not
And
at,
the
may not be admissible.
consignment details also not is in, there is no reflection.
Hey, Yeshu. The petitioner says that he has been falsely implicated, stopped, just because he has a medical store, comma, his name has surfaced in the charge sheet file,
Charge sheet not.
in the FIR names him.
Yes, yes.
In the FIR, stop. There was no recovery from him, stop. He has been implicated solely on the basis of statement made by a co-accused person. Stop. He prays for anticipatory bail, paragraph. Learned State Council shows me the statement of one Narayan De, who is a co-accused person, confessional statement of one Narayan De, who is a co-accused person, comma, recorded under section 161 CRPC. Stop. He names the petitioner as the owner of the medical store from where the concerned contraband items were collected. Stop. The Learned State Council says that apart from that statement, comma, there is no other material against this petitioner. Stop. Even the consignment numbers of the concerned bottles of fencidil,
Yes, ma'am.
of fencidil syrup are not available. Paragraph. I therefore see that the only material against this petitioner is the statement of a co-accused recorded before the police, comma, which
Not fencidil, is X-cough tea. X-cough tea syrup.
X-cough tea.
Caesar list 7 and 8.
XCOF dash T. Now capital, huh? X-cough tea. Which may not be admissible in evidence. Stop. Paragraph. In view of the aforesaid, comma, I am of the view that the petitioner has been able to tide over the restrictions in section 37 of the NDPS Act, and I am inclined to allow his prayer. Allow this application, correct? Allow this application. Supplementary is what you're filing today. প্রথমে তাই লিখে নাও, supplementary affidavit filed by the petitioner be kept with the records.
It's a proper noun, but they have spelled the blood.
আর তারপরে leave is granted to learned advocate on record for the petitioner to correct the spelling of the petitioner's name as mentioned in the cause title. What will you correct? To correct the as mentioned in the cause title of the bail petition.
That's all, madam.
29. The effect of complainant, why you have issued a circular, that was to Your Honor, I have made a I have demand of that.
De facto complainant?
That was Your Honor, I have deposited that.
Issued a check in your favor? Yes.
And I have the I have lodged taking the effect of complainant.
CR case
Charge sheet already.
when the CR case was filed?
That other document you have only comes in number 14 of my.
Wait, first slide. How many? 30th April 2000. The CR case was filed on 30th day of April 2024, but this case was started on 29th of February 2024. Much earlier from the
No, but
CR.
preceding the CR case would be a demand notice, na? And the
Demand notice within 1 month, it has to be, so even the demand notice when it was sent.
The page, now I got page number 14, para number 10.
Para number.
Yes, but
Demand notice was
legal-
duly received on 18th of March.
legal
2020.
notice was also after
After of this.
they have
case.
initiated this case. But anyway, what material is
Thing
there?
is that, my lord, this petitioner, he just made this complaint and said, I'll be doing a credit work for you. And on the basis of that, he has taken 11 blank checks from her. And one of the checks has been, which he has dropped. It was dishonored. Thereafter, he sent a notice. This is the case. But prior to all these things, the affair was lost.
11 blank checks the de facto complainant gave to the petitioner.
That is the case for that.
De facto is a lady.
Oh, Anamika Rai.
Take it by the level of what? Try to complete part.
Charge sheet?
Charge sheet filed on 31st of December 24.
Why did you take blank checks?
According to my plan.
No, he is a dangerous character. You go and surrender. No, no, no. These kind of people are very dangerous. Unsuspecting people. Issue. Filed because you were absconding. What can be done? No. These kind of people are dangerous for the society. The petitioner says that this complaint is a counterblast. Stop. The wife of the de facto complainant had issued a check in his favor. Stop. When the check was dishonored, comma, the petitioner sent a demand notice. Stop. Upon receipt of the notice, comma, this false complaint was lodged. Stop. He prays for pre-arrest bail, paragraph. Learned State Council shows me from the material in the case diary that
No. Before server notice.
No, kindly see the page number 14. I have downloaded 15 March. They have launched the FIR on 18/4 below.
18/4. This affair is of
18/4 below. Sir, kindly come to page number.
Page number.
Page number. Sir, kindly come to annex P2.
you say 29th February.
That is the
Mr.
date,
Chakravarti?
my lord, in the affair.
देखिए तब. You can't improve upon the case diary, sir.
On the right side, my lord, it's written 29.
Yes, 29th.
Annex P2 मिला.
बड़ा मुश्किल है देखने.
18/4 मिला. Your FIR is 18/4.
After inquiry, affair may be registered.
1/8/2024, dated 18/4/2024. FIR itself will not be stating that.
The written complaint is dated 29th February, sir. Hey, Yashutu. কি হলো কত কথায় পৌঁছেছি? হ্যাঁ?
Page number 8 पर आप-
Paragraph.
page number 8 मिला.
Now I will dismiss with costs. Yes, should be.
Page number 8.
Issue. Learned State Council, comma, with reference to the material in the case diary, shows me that the written complaint was made on February 29, 2025,
Received 20.
whereas the demand notice was sent by the petitioner allegedly on March 15, 2025. Stop. Paragraph. Therefore, I see that the contention of the petitioner that the present complaint is a counterblast is incorrect. Stop. It further appears that the petitioner induced the wife of the de facto complainant to sign 11 blank checks and hand them over to the petitioner. Stop. The petitioner's wife, the de facto complainant's wife, did so in good faith. Stop. Although the same was not a wise thing to do. Stop. People like the petitioner are dangerous for the society. Stop. Paragraph. Now we can add to Lekho. Stop. They cheat unsuspecting people by playing confidence trick. Stop. Paragraph. In view of the prima facie material against the petitioner, comma, although charge sheet may have been filed, comma, I am not inclined to allow the petitioner's prayer for anticipatory bail. Very bad case. Worse than this one.
My lord, abscond charge sheet. Tuesday, I'm 6 or 9. 9th, my lord.
Ninth.
8th, I won't be able to.
9th.
31.
Sir, handed over this to me for making submission, but it seems that I stood on behalf of the state in another case.
Then better not. Better not. Not today. Mr. Ganguly, do you know Pritam Roy? He practices in this court here. Is he in court today? Please ask him to see me once in my chamber.
32.
And specific reading that my daughter-in-law residing with me, he has no problem. If your lordship directed,
Daughter-in-law meaning the victim residing with you.
then I will be represented immediately.
Monday? Monday? Chalo. The last matter, madam, you also find out if what she says is correct. And order record kore daw to, shubidha hobe. The petitioner is the father-in-law of the victim, lady. Stop. The charge is under section 498A oblique 307 IPC. Paragraph. Learned counsel for the petitioner says that the husband of the victim has been granted bail. Stop. The victim lady is residing in the matrimonial home along with her husband and in-laws, including the petitioner. Stop. Paragraph, let the state make due inquiry and find out the correctness of the aforesaid submission. আচ্ছা আগের প্যারাগ্রাফের আরেকটা বলে দাও। The victim lady has no objection to the grant of anticipatory bail to the petitioner. Find out. Paragraph lists the matter on 7th, April 7th.
Just receive the case diary, Lordship.
Yes,
Just receive the case diary. One day.
one day. Not today.
34.
Pass over.
35.
I'm for the state.
Fact of complaint, Lordship, the allegation is that repeat rape upon the wife, upon the lady, Lordship, de facto complainant, who is a PhD holder student of a particular university, and the petitioner is also an adult person. Lordship, there is a love relationship between the petitioner and the de facto.
But the service has been effected. Effective service has been done.
Yes, 376. Service has to be effected.
Not POXO.
No, it doesn't matter.
376 is there.
Yes.
Victim is the party, victim is the opposite party.
Then fix it, twist.
Yes, victim is an opposite party.
Yes, Lordship.
Then you have to serve.
Then
Yes.
on twist, fix on twist.
Service is yet to be effected on the victim girl. Stop. On the request made by learned advocate for the petitioner, comma, let this matter be listed again on 8th, April 8. Stop. In the meantime, let service be effected. Stop. On the adjourned date, affidavit of service shall be filed in court.
Have.
Lordship, service has not been completed. Kindly fix the matter on Tuesday.
Learned advocate for the petitioner says that service is when? When do you want it?
Tuesday, Your Lordship.
Oh, tell same order. Service on the victim girl.
Yes, Your
Same order.
Grateful, Your Lordship.
37.
CD is not there. Not today.
38.
Lordship, I have the petition, Lordship. Lordship, other than all section, pertinent section is Lordship 307. Lordship, allegation is that while de facto complaint harvesting crops, the accused and with the present petitioner went through the crop cutting machine with the upon the crops. That is the allegation only, and case and counter case as.
When the petitioner was cutting crop,
Yes, Lordship.
petitioner,
No, Lordship, de facto complaint.
yes.
De facto complaint.
Then the accused persons did what?
Went through with a crop cutting machine upon that crops. That is the allegation only. Lordship, case, counter case is there, and two other
Lordship,
persons
the
already.
injury
bailed.
sustained by the Caesar, your lordships. And that there is an injury report, kindly see the multiple injury, but written that nature of the injury simple, although there is a injuries.
Yes, crop cutting, it can happen. It always is happening. এর ছাগল ওর বাগানে ঢুকে গেল। Yes,
Although my objection.
Charge sheet.
Charge sheet
No,
not filed.
Lordship.
The petitioner says that the incident arose in relation to a dispute regarding cutting of crops. Stop. The petitioner had no intention to hurt anybody. Stop. He is fully prepared to cooperate with the investigating officer. Stop. He prays for anticipatory bail. Paragraph. learned state counsel, comma, while opposing the prayer, comma, shows me the injury report, medical report, karo. Stop. The injury sustained by the victim has been described as simple try karo, inverted comma. Paragraph. On an assessment of the material on record, comma, the nature and gravity of the alleged offense and the possible extent of complicity of the petitioner in the alleged crime, comma, I am of the view that immediate custodial interrogation of the petitioner may not be necessary so long as he fully cooperates with the investigating officer. Bole usual, huh?
Lordship, I'm for the petition, Lordship. Here is also allegation under section, pertinent section is 326, Lordship.
What happened?
Lordship, de facto complainant's son and this petitioner's sons are the friends. And at night, at around 10:30 PM, both were fighting over phone, over some mobile phone. And after that fight, after the petitioner, this present petitioner is the father of this son, and hearing all this shouting, he came out from this from his house, and the de facto complaint has already written in his complaint that there is a past enmity, and for that this petitioner has brought in this case of production.
Yes.
Lordship, assault by the lathi over the head, and stitches are there. Cut injuries also there, Lorships. Kindly see, Lordship.
They are neighbors.
Yes, Lordship.
Measure of the injuries also reflect.
Lordship, we will cooperate with the police, Lordship. That was not submitted.
Neighborly dispute, they'll cooperate, sir. Why do you need him in custody? The only question. And there's no chance of absconding. Family man.
What should be done?
Yes, of course. The petitioner says that he has been falsely implicated. Stop. There was a dispute there was a quarrel, Karo, between his son and the son of the de facto complainant. Stop. The de facto complainant and the petitioner are neighbors. Stop. To stop the two sons from fighting, comma, the petitioner went to the place of occurrence. Stop. Hence, he is falsely implicated. Stop. The FIR itself would show that there is past enmity between the two families. Stop. He prays for anticipatory bail. Paragraph. Opposing the prayer, comma, learned state counsel shows me the medical report. Stop. The victim did sustain injury, but the same does not appear to be grievous. Stop. It prima facie appears from the material in the case diary that the incident involves neighborly disputes. Stop. Paragraph. On an overall assessment of the material on record and the nature and gravity of the alleged offense, comma, I am of the opinion that immediate custodial interrogation of the petitioner may not be necessary so long as he cooperates with the investigating officer. Kore, normally what I direct, within 7 days, he'll report to the IO. Every fortnight, and as and when he is called for by the IO, he will. I will come back in 5 minutes.
Lordship, 40 I'm bringing for not to 10, 40 and 41. Great.
42.
42 also, I am for the petition one.
Let me make it Monday. 43. State Lordship, pass over Lordship.
Pass over.
43 Lordship.
Transferred on the basis of statement of avoidance.
No recovery.
I probably investigating, no other intimating material after my.
No CDR, no money trail, nothing.
Lordship, this petition is a supplier as per statement of the.
Co-accused. Cooperate করবে আর কি করবে এসো The petitioner says that there was no recovery of narcotics from him. Stop. He has been implicated solely on the basis of statement made by a co-accused person. Stop. He is fully prepared to cooperate with the investigating officer. Charge sheet not filed. Stop. He prays for pre-arrest, pre-arrest, bail. Paragraph. Learned State Council, while opposing the prayer for anticipatory bail, fairly admits that there was no recovery of contraband items from this petitioner. Stop. He has been implicated solely on the basis of the statement made by a co-accused person to the effect that that he is the supplier of the concerned narcotic items. Stop. Paragraph. To my query as to whether or not there are call details reports or money trail, call details report or money trail linking this petitioner to the alleged crime, learned state advocate fairly says that no such material is available. Stop. Paragraph. In the above facts and circumstances, I am of the opinion that the petitioner has been able to tide over the restrictions in section 37 of the NDPS Act. Stop. I am inclined to allow his prayer for anticipatory bail so long as he fully cooperates with the investigating officer. Condition গুলো একটু পাল্টাচ্ছি রোজ দেখে নিও আজকে 7 দিন এমনি যা আছে 7 দিনের ভেতর আইওর কাছে সারেন্ডার করবে every fortnight and as and when called for আইওর কাছে যাবে আর বাকি যেগুলো আছে
44.
44 and 45, there is no CD.
And then wisdom.
8th April.
Great woman.
Forty-six.
46, 47, 48 were fixed at wisdom.
Why?
But at last, today appearing the list where CD has not come.
Next.
48. 49.
For item number 49, I'm going for keep the matter on Monday.
Not today.
Wait.
50.
I'm for this.
Milord, this is renewal of
Service.
service has been done, Milord. This is my affidavit of service.
Dekhi service. Is the notice in form?
Yes.
Maybe not. Let me check. Have you informed him of the right to be represented through a lawyer to be engaged by? Where's the notice? এই খামের ভেতর কি আছে? Track report. Where's the notice?
That's the entire copy of the petition through post.
22.
I'm for the petition, Your Worship.
I'm available for the petition.
Restoration of petition.
You are surely not opposing this.
No, my lord. Up to the court. Your Lord.
Paragraph, ye likho.
Correct.
This is an application for restoration of CRM bracket A 896 of 2024, which was dismissed for default on January 6, 2025. Stop. Beyond time. Beyond time.
I have explained it in paragraph number 4.
Paragraph, having heard learned counsel for the parties, I am satisfied with the explanation furnished for absence of learned advocate for the petitioner on the day the application for anticipatory bail was dismissed for default. Paragraph, accordingly, comma, the order dated January 6, 2025 is recalled. Stop. CRM A 896 of 2024 is restored to its original file and number. Paragraph CRAN 1 of 2025 is disposed of. Paragraph, this the application for anticipatory bail on Monday, the other.
Monday, my lord.
Grateful.
Wait.
नहीं क्यों
Before I'm appearing on behalf of the applicant, Your Lordship, in this matter, Your Lordship, what has happened that while granting bail to the present petitioner via an order dated 21st of January 2025, Your Lordship, there is a direction to meet the investigating officer once a week, Your Lordship. But on 13th of March, Your Lordship, the wife of the petitioner had developed some infection. She is a patient of post-transplantation of kidney, Your Lordship. So for that, he had to rush her to Kolkata, Your Lordship. And subsequently, with leave of this honorable court, Your Lordship, the relaxation of condition, this application was filed before the principal bench, Your Lordship. So if that would be waived, Your Lordship, the condition to meet the investigating officer, because she is under treatment and she
treatment where?
in Kolkata, Your Lordship. I have annexed the document in my petition and she is a patient from page 22. It would.
So you have settled down in Kolkata now?
He has returned back for this on subsequent to filing of that, Your Lordship.
What about, because January is just 2 months ago.
Yes, Your
What
Lordship.
about once a month if we say?
Yes, Lordship, kindly look at the compliance report which the IO has submitted. This person, Lordship, has failed twice to appear before the
Yes, Your
IO
Lordship.
and Lordship, because I don't know, yes, the person did not give reasonable explanation to the IO stating the illness of the Lordship wife.
And I have annexed the document of admission, Your Lordship. It's on 3rd.
And also, Lordship, he did not cooperate with the recovery
So
of the
Mr.
stolen
Luxem,
property.
Mr. Luxem, I'm not going to waive it altogether.
Yes, yes, Lordship.
But make it, relax it, make it once a month.
Grateful.
If his wife is really ill, which it appears, renal failure, transplantation.
The admission is of page 16 of my petition, Your Lordship. It would show that she was admitted on 13th of March 2025, Your Lordship. And she is a history that is in page 22 of my petition, Your Lordship. At the history, T2DM since 16 and subsequently LURAR, which is leaving unrelated renal transplant, Your Lordship. She has a history of that. and
No,
she
look here, the order granting you anticipatory bail further says that you shall appear before the jurisdictional court and pray for regular bail.
has been complied with, Your Lordship.
Regular bail has been granted.
Yes, Your Lordship, that has been complied with.
But
If regular bail has been granted, then how is this relevant anymore?
Bail has been granted, but Lordship, he has to cooperate with the investigation officer, Lordship, because he is not satisfied regarding the recovery of the stolen articles, Lordship. So he has not cooperated with him. So that is why the Thana Adira was important.
No,
Lordship.
no, yes, that's all right, but regular bail has been granted.
Lordship. Lordship has been granted.
that has been complied with your lordship.
So this one, we'll make it once a month then.
Once in a month, but Lordship, upon satisfaction of the high officer, because he has not cooperated with the investigation regarding stolen articles, and also he needs to furnish the Lordship documents to the IO, Lordship, regarding the illness of the.
That we would comply with your lordship.
The petitioner was granted anticipatory bail by a division bench on January 21, 2025, inter alia on the condition that he shall meet the investigating officer once in a week until further orders. Stop. Paragraph. The petitioner says that he has been complying with the said condition. Stop. On a couple of occasions, he failed to meet the investigating officer because of acute illness of his wife, who is a patient of renal failure and has undergone kidney transplantation. Stop. He had to rush to Kolkata for medical treatment of her wife. Stop. He prays for waiver of the condition requiring him to report to the investigating officer once in a week. Paragraph. Charge sheet has been submitted? No.
No.
Are you sure?
Stolen articles, because. No.
No.
Investigation of the case is proceeding for recovery of the stolen article, stolen oil tankers, and to honor the fact behind the theft.
Learned state advocate tells me that the investigation is still in progress. Stop. It is important that the petitioner reports to the investigating officer and cooperates with him so that the stolen articles can be recovered. Stop. Paragraph. I am not inclined to waive the aforesaid condition altogether. Stop. However, I see from the documents annexed to the present application that the petitioner's wife is indeed under medical treatment in Kolkata. Stop. This may require the petitioner's presence in Kolkata quite often. Stop. Therefore, taking a lenient view and on humanitarian grounds, I modify the condition requiring the petitioner to report to the investigating officer once every week and permit him to meet the investigating officer once every month. Stop. However, whenever the petitioner goes out of, he lives in Jalpaiguri, out of Shiliguri, he'll send prior intimation to the investigating officer. Stop. Anything else? No, that is all.
And supply the documents of the hospital to the IO, Lordship.
He shall also supply all the medical documents pertaining to his wife to the investigating officer. Paragraph. The other conditions mentioned in the order dated January 21, 2025 remain unaltered. Grand disposed of. Break it out.
Item 3. And for the petition. I'm for the petition. My lord, present petitioners are the in-laws of the deceased VG, and entered allegation is leveled against one Hamida Rahman. He already enlarged on bail by the learned trial court below. And the case was initiated on 2nd of December 2024, and husband of the deceased VG and brother-in-law of the VG.
Who is Hamida? Mother-in-law?
Husband of the VG.
Hamida Khatun.
No, my lord. Hamida Khatun is mother-in-law.
Who is Abeda Khatun?
She is wife of the brother-in-law of this is VG.
Wife of the brother-in-law.
That means
Of the deceased.
deceased.
And Rumpi?
Same wife. Same.
I see. So they are the sisters-in-law
Sisters-in-law.
of the. Yes.
My lord.
Main allegation is against?
Hamida Rahman alias Rana, who is enlarged on bail already from the trial court.
Hamida is the name of a man.
Hamidar. My lord.
Hamidar.
Hamidar Rahman.
Acha. Hamidar Rahman. Yes.
Lordship, 164 statements are there of the niece and the nephew. Lordship, similar allegations are there.
Omnibus allegations,
Yes,
but
Lordship.
main accused is the
Yes.
husband.
Husband. His husband.
He is in custody.
No, my lord. Yes. He is on bail. He is on bail.
He's on bail.
Learned trial court bail.
Esho. Charge sheet.
Charge sheet not filed, Lordship. Charge sheet.
The petitioners, the petitioner number one, the petitioner number one is the mother-in-law, and the petitioner numbers 2 and 3 are the sisters-in-law of the victim lady who has passed away. So they say that the prime accused is the victim's husband, who was taken into custody but was subsequently enlarged on bail by this court.
Learned trial court, CGM Jalpaiguri.
By the learned trial court. Stop. They have no role to play in the alleged murder of the 302.
My lord, there is a 81 and 101 of the 108 of the BNS. 306.
Oh, committed suicide. Committed suicide. In the alleged suicide murder coroner. Suicide of the victim lady. Stop. They pray for anticipatory bail. Stop. They say that they will fully cooperate with the investigating officer. Paragraph. Learned State Counsel shows me the statements of witnesses recorded under section 164 CRPC. Stop. The allegations against these petitioners are general and omnibus in nature. Stop. The main allegation is against the husband of the victim lady. Stop. I've also seen the post-mortem report. Stop. It appears that the victim lady committed suicide. Stop. Paragraph. Considering that the petitioners are ladies and housewives, and also considering their extent or possible extent of complicity in the alleged crime, comma, I'm of the view that immediate custodial interrogation of the petitioners may not be necessary so long as they cooperate with the investigating officer. আচ্ছা, প্রথম 7 দিনের ভেতর হয়নি চার্জশিট, আইও, আর তারপরে as and when called for. আচ্ছা, ওখানে and also noting that the prime accused has been enlarged on bail. ওখানে একটা add করে দিও.
Deeply okay.
Today is the fourth occasion.
No, this, we'll pass it over intercessory. Call him, call him. Pass over. Is he in court?
Yes.
11. Pass over. I'll make a third call immediately. This is not. Saurabh Ganguly. Pass over. See, send him a word if possible. 25. You're for the state, you're for de facto. Come.
But offense under section 365, 468, 471, 472, 34 of the Indian Penal Code, and 376, 323, 506 of the Indian.
Victim recovered.
Victim recovered, principal accused is on bail by the learned court below. I have annexed the order. Kindly see page 11 of my application. One Rubel Hawk is the principal accused. He took away the victim girl. Allegation is that he took away the victim.
Victim lady, adult.
Lady. Rubel Hawk is a principal accused. He is on bail by the learned court. As per the FIR warrant, this petitioner and two others by the help of
Bail is the principal accused. If he is on bail, why then? Charge sheet? Submitted. Issue. I'll record your objection. The petitioner says that he has been falsely implicated. Stop. He has no role to play in the alleged offense. Stop. The principal accused being one
Rubel Hawk.
Rubel, R-U-B-E-L, Rubel Islam.
Hawk. Rubel
But the girl has said Rubel Islam.
Hawk allies Islam.
Rubel Hawk alias Islam has been granted bail by
By the learned session judge.
the learned sessions judge. Stop. Investigation is complete. Stop. His custodial detention is not necessary. Stop. He will always cooperate with the police. Paragraph. Learned state counsel and learned advocate for the de facto complainant propose the prayer for anticipatory bail. Stop. I've been shown the statement of the victim lady recorded under section 164 CRPC. Stop. She names Rubel Islam as the principal accused, principal offender. Stop. Paragraph. On an overall assessment of the material on record and the possible extent of complicity of the petitioner in the alleged offense, comma, noting that the principal accused has been enlarged on bail, comma, bail and charge sheet has already been filed, comma. I am of the opinion that immediate custodial interrogation of the petitioner may not be necessary so long as he cooperates with the police. তাহলে এখানে ও 7 days এর ভেতর সিএস পুলিশ স্টেশনে কেস রেজিস্টার্ড হয়েছে কনসার্ন বলো না হ্যাঁ মাথা ভাঙা আর তারপরে এভরি ফর্টনাইট রিপোর্ট করবে fortnight and as and when called for. Not to enter what? Tell us. Tell us which one. Not to enter.
He is the resident of Kotwali.
They are stay outside. You can't have everything. পেয়েছো কোতোয়ালি de facto যেখানে থাকে সেটা তুমি কি করে খুঁজে পাবে হ্যাঁ সেই জন্য কোতোয়ালিতে ঢুকবে না হ্যাঁ যেখানে থাকবে তার অ্যাড্রেস পাবে
Waiting for a day's accommodation, but let it be taken up on Monday.
As well.
Relaxation, my lord, making the twice in a week, my lord. Once in a week.
This is 7th of January this year.
Submitted a similar was not granted another required to cease. My lord. Also, my lord, relaxation, my lord, waived.
Totally waived.
Another required.
Lady or who accused? Where is that order? No. Finish it off. Yes, sir. He has been complied with the.
CD not put it.
Don't need the CD.
Did the report call for lordship?
The petitioner prays for relaxation of.
I annexed all attendance in my absence. Only attendant.
Let them file a report, Mr. Gully. And you bring that order also. Prays for relaxation of conditions of anticipatory bail which was granted to him on January 7, 2025. Stop. In particular, he prays for waiver of the condition requiring him to report to the investigating officer every week until further orders. Stop. He says that charge sheet has been submitted upon completion of investigation. Stop. Therefore, it is not necessary for him to report to the investigating officer every week. Stop. Paragraph. Let the state. Now, the petitioner further says that a similar condition that was imposed on a co-accused person who was also granted anticipatory bail, has subsequently been waived by this court. Stop. Let that order be produced on the next date. Paragraph. The state shall file a report indicating whether the petitioner has been complying with the conditions of anticipatory bail. Paragraph. Monday or Tuesday?
Tuesday, lordship.
Tuesday. 8 तारीख. পাস ওভার ছিল না দুটো?
Item number 4.
You are appearing. Who is senior is come. Not today, not today. Nobody is present, not today.
Eleven and question, my senior was Mr. Ganguly is appearing.
Not today.
Without CD, my lord.
11 and 2.
Sure, not today. There is a 3:30 rising today. You follow it here normally?
Yes, ma'am.
At the end of the week. Yes, sure. 2 o'clock division bench. Oh. Yes, I have just gone for orders after that division bench.
Lordship, may I be permitted to mention one thing, Lordship? Lordship, am I audible, Lordship?
My lord, for inclusion in the list, ma'am.
Why wasting time? Just give it. Inclusion handover, inclusion don't mention.
Your Lordship mentioned ACBM mal, but it is actually ACBM process. Therefore, it's therefore correction.
Bail in connection with appeal.
To be mentioned Monday.
One upgradation is a criminal appeal, or it's a running in the as item number 94 in the database. Is a old aged lady malord suffering.
Upgradation not possible.
It's a old aged lady malord.
There are several such cases. Then we have to upgrade 25 matters.
Which section the case?
Malord 302.
He's in custody.
He's in custody, convicted.
How long custody?
Malord, almost malord 1.5 years.
Let us see. Let us see how it goes. Next.
Mentioned, my lord, it's an arbitration of it. Praying for compensation of.
What do you want? Inclusion, just hand up the slip.
Maybe not to permit. Mentionable. My lord, we have filed a WP LRTA.
Yes.
Against the arbitrary proceedings of the land tribunal.
Yes.
Wherein I am not allowed to, I'm precluded from withdrawing my application.
Don't argue your case. You want inclusion?
Yes.
Give it.
Now may I have my lord's kind leave.
Yes.
My lord, to mention my lord an appeal, my lord on 12th of May 2023, when my lord was taking up the division bench, my lord sitting in the Jalpaiguri bench. My lord had appointed one of the learned advocate, my lord Mrs. Priyanka Dhar, as my lord the joint my lord receiver of a petrol pump. Now, my lord, the issues are my lord on the verge of my lord she, because of my lord their professional obligations back at Kolkata, is not being my lord, it's in difficulty to carry out my lord with the my lord the job of my lord the joint special officer.
Mr. Dashgupta.
My lord, if my lord kindly my lord, I'm mentioning on notice on everybody. My lord,
No. On oral submission, sorry. Put something on record, file a 2-page application, whatever it is. There must be something on record.
very.
All right. Next. Yes.
Very well. I tried to, my lord, but they are of the my lord, the department is of the view to it has to be go and my lord, be affirmed there.
Yes.
For that only I took my lord.
Yes.
I'll do that.
Put something on record. Then we'll see. Yes.
I will.
ওহো তুমি আশ্চর্য মনে করাবে তো দুজনে বসে সিঙ্গেল বেঞ্চ হয় ভুলে গেছি আমিও হ্যাঁ একটা ছিল না ছাড়ো বসে পড়েছি I'll deliver the order at 3:30 just before rising. Then we'll rise. I'll come back, deliver the order.
My lord, may I mention one matter? Okay, sir, my lord was pleased to keep the matter fixed today, retaining its position because the learned DSG was out of station. But now the matter is showing out, the date is given on 10th of April.
Date is mentioned.
Yes, in the case status, it is mentioned as 10th of April.
Is it not appearing in the
No,
list?
my lord.
কেন হয়েছে কি হয়েছে দেখে নিও পরে কৌশিক we'll see.
Hello.
Call the list.
Item number 1.
For correction কেন কিসের correction? তো সেটা কেউ নেই তো হ্যাঁ এসিজিএম নেই কুচবিহারে তাহলে স্যাটিসফ্যাকশন অফ কে হবে তাহলে না নেই তো নেই ওদের প্রবলেম নট টুডে করে রেখে দাও Yes.
Item two, my lord, I am for the my lord applicant, my lord. In this case, my lord, I am appeared.
I am for the state. I have the copy of the suspension application, but judgment is not annexed.
Lord, I will serve the copy in the meantime. Lord. This is the my lord, I got the brief from the legal aid service, my lord. That I have requested the copy of the my lord evidence, my lord. The copy was not given. If the office directed to give me the copy, I will serve the both to the me. as well.
Yes, 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 do that. But
Can you keep the Wednesday matter?
Wednesday. The department should make available copies. Cost ki kotheke bölbe? Who will pay the cost of xeroxing and all?
This legal aid matters, my lord.
Department does it. Oh, very well. Learned advocate for the appellant says that, appellant oblique petitioner says that he has been appointed by the High Court Legal Service Committee. High Court Legal Service Committee. Stop. Paragraph, let the department make available to learned advocate for the petitioner copies of the depositions of the witnesses, as well as the deposition of the accused on being examined under section 313 CRPC. Stop. Let this be done by the end of office hours on April 7. Paragraph lists the matter, April 9. Paragraph, learned advocate for the petitioner shall make available to learned advocate for the state copies of the aforesaid documents.
My lord, with unconditional apology, my lord, while calling at item number 1, I was on my legs at court number 2, my lord. That's why I couldn't appear, my lord.
Go back to court number 2.
My lord, I couldn't appear.
Go back to court number 2.
For a small correction, lordship.
What is this? This is a division bench, sir.
Lordship.
You must have your priorities clear.
Lordship. At that time, my matter was.
Come back on Monday. D'accord. D'accord. Come back on Monday. Learn, sir, learn.
For the appellant petitioner here.
Straight.
Ready?
My lord.
You ready?
89
My
appellant.
lord, paper book is ready, my lord. It is, my lord, within my chamber, my lord. I will get it within 5 minutes. My lord.
Item number
Sir,
3.
my senior friend.
I have annexed all the evidence, certified copy.
He is brief. His file is lying in the chamber. Pass it over. We'll take it
My
out.
lord.
I'm for the appellant lordship.
statement.
Lordship, the present application is under 415 subsection 2 of the Bharatiya Nyaya Suraksha Sanghita. Suspension of sentence, lordship. Appeal has been admitted, appeal has been condoned, and in the trial court, the accused was defended by one advocate appointed from the legal aid authority.
10 years, sentenced to 10 years. 6 years already in custody.
Lordship. And lordship, the victim girl at the time of
More than 50%, more than half he has served.
victim is 58 years old and accused was 48 years old at the time of.
Sure. We are not calling upon you to make submission. This is an application for suspension of sentence in an appeal filed by the petitioner against the judgment and order dated August 3, 2022, passed by learned additional sessions judge, First Court, Darjeeling, in sessions trial number 01 bracket 11 bracket closed of 2019, arising out of sessions case number 25 of 2019, whereby the petitioner was sentenced to rigorous imprisonment for 10 years, and also to pay fine of rupees 10,000. Stop. So after 10,000, for commission of offences under section 376
Lordship, 376.
IPC. Stop. Paragraph. The petitioner says that he has already served 6 years in custody. Stop. He is now 40, 50.
He is now, Lordship, at present, the petitioner is 55, 56 years old.
At the time of commission of the alleged offence, he was 48 years old. Stop. The victim lady was 58 years old. Stop. He has already served more than half of the term for which he was sentenced. Stop. There is no certainty when the appeal will be heard. Stop. Paragraph on merits also, the petitioner says that there are certain loopholes. Stop. He has shown us the depositions of PW1 being the victim, as also PW12 being the examining doctor. Paragraph. Learned State Counsel says that the judgment under appeal is well reasoned and well informed. Stop. There was sufficient evidence for the learned trial court to reach the conclusion that it did. Stop. However, on the score of the petitioner having already served more than half of the sentence imposed on him, he leaves the matter to the discretion of the court. Paragraph. We have considered the facts and circumstances of the case. Stop. We do not wish to express any opinion on the merits, lest it may have some effect on the hearing of the appeal. Stop. Paragraph. We, however, see that the petitioner has already spent 6 years in custody. Stop. He was sentenced to 10 years imprisonment. Stop. Isn't there a provision also in the CRPC? CRPC?
That is for under trial.
Under trial prisoners. Stop. Paragraph. Hence, solely on the ground of the petitioner having served out more than half of the sentence and there being no certainty of the appeal being heard on an early date, we are inclined to and hereby do suspend the sentence of imprisonment and grant bail to the petitioner pending disposal of the appeal. Kuri usual conditions kore diyo. Fine. Haven't we stated that at the time of admission? When was it admitted?
6/12/2024.
6.
Lordship, order dated 6/12/2024. No, it was delay zero, delay.
That is only,
Condonation and admission.
Only appeal.
That's fine, just stay fine.
no, admission কোথায় আছে? ও আচ্ছা, হ্যাঁ। হুম, হ্যাঁ,
10-1 and 10-2.
আরেকটা করে দাও। We also stay the operation of the direction to pay fine pending disposal of the appeal.
Obliged.
Lordship, paper book direction.
Paper book direction দেখি। Paper book direction নিশ্চয়ই আছে। Paper books be prepared, direction is there.
The legal aid matter, Lordship.
They don't pay anything.
No, I'm doing pro bono.
You are doing, but do they offer anything?
No, Lordship, because my name is enlisted as the only pro bono lawyer here.
Oh, but to the others?
Others, they pay.
They pay.
Doesn't need one.
From endorsing products,
Everything is.
thousands of crores.
Not to speak of what is paid by BCCI. Lordship, in this matter.
The other one, Passover Institute, no. Anyway, tell us, once he comes with his paper book, tell us.
The delay convolution. My lord, if I'm permitted, my lord, an identical matter is in your lordship's list as item number 9.
That is the condonation.
Yes, ma'am.
I've gone through the judgment, it applies, section 5 applies.
Same is the case here.
Yes.
Though it has been marked as defective, your lordship will remember, if your lordship kindly recalls.
So have you filed a section 5?
But leave has been granted, my lord. Leave has been granted. After that, the registry has noted that the appeal is defective. 60 days delay has been.
Yes, but that delay has to be condoned. Section 5 will apply. Now that is established by Supreme Court.
Kindly allow me
Yes.
to file a crime.
When should we keep it?
Any day next week, that Wednesday.
Wednesday. The department লিখো না। কোথায় গেল তো এটা? তোমার কাগজে আছে কোথায়? হ্যাঁ, আচ্ছা আচ্ছা, হ্যাঁ।
সব থেকে বেশি মঙ্গল।
The department has noted that there is a delay of 360 days in presenting the appeal. Stop. Paragraph. Learned Deputy Solicitor General requests that this matter may be listed on April 9. Stop. In the meantime, the Union of India shall file an application for condonation of delay. Stop. Paragraph. Let this matter be listed on April 9. Stop. If in the meantime any application is filed by the Union of India, let the same be listed along with this appeal on the agenda date.
Obliged, madam.
File and serve it.
That's. And the service.
For the appellant. This is appeal against the conviction of 20 years and with 50,000 of rupees and
Section 6.
of POCSO.
Hey, this is an appeal against an order of conviction, usual. Fine stayed, usual. Nah, within time. সব থাকে, ওই তো স্ট্যান্ডার্ড ফরম্যাট করে দেওয়া আছে। Next one, call the next one after that.
Lord. After that.
After that.
For the state.
Wait, please,
Admission
minutes.
of appeal, there is a delay condemnation application, 124 days delay.
Nobody is there.
Please, minutes. I beg to appear, minutes in item 7 minutes.
Oh, hey, Grant now.
Uh,
Grant 2 is the condemnation or Grant 1?
Please, minutes. Cran 1 is the continuation of delay minutes. Cran 2
Grant
is
1,
suspension of
this
sentence.
is an application for condemnation of delay of
24 days. Minutes.
24 days in presenting the appeal. Stop. The causes shown being sufficient, comma, the delay is condoned. Grant 1 is disposed of. Now take, what is Grant 2?
Minutes, suspension of sentence. Minutes.
Okay, first we have to admit the appeal.
Please, minutes.
Take appeal to now, Matt. Usual order. This is an appeal against an order of conviction. Kore admit the appeal, etc., etc., etc. And the suspension we'll hear on Monday, madam.
Please, minutes.
Let it be Tuesday.
Tuesday. Everybody Grant 2 to now. Kore, this is an application for suspension of sentence and grant of bail. Stop. On the request of learned advocate for the state, comma, let this matter be listed again on April 8.
Yes, judgments are all annexed with your petition. The copies of the judgment is annexed with your petition.
Yes, yes.
Please verify all this.
Yes, I have all the papers.
এইটা শোনো
Just after I said I am grateful, Mr. Mojumdar is saying that he is acknowledging that I am grateful.
No, my lord, the reason being, sir, I told him that Arjun, since
two separate words or say?
no, my lord, that is for judicial interpretation. My lord. I said married man need not say that.
My lord, 389 application, suspension of sentence.
Yes, sir, 16 years in custody. Circumstantial evidence.
16, not 16 years, my lord.
Not 16, how long?
My lord, all along I was on bail, my lord.
Oh, you were on bail?
I was on bail, my lord. I was taken into custody only on the date of pronouncement of the judgment.
Oh.
That is on we had circumstantial evidence. There is nothing.
Judgment to 24 years.
2024. Yes.
All along bail.
All
He never
along
jumped bail.
There is nothing against me, my lord. Except the last thing together, it's baseless, my lord. I can demonstrate, my lord.
1, 2, 3, my lord.
We have seen that this is why we carry the files home. It can't be said that he has no argument at all. He may fail in the appeal ultimately. We don't know. Correct. We'll grant him bail, sir. Esho. This is an appeal. This is an application for suspension of sentence in an appeal filed against the judgment and order dated April 16, 2024, passed by the learned additional district and sessions judge, 4th court, Jalpaiguri, in sessions case number 263 of 2012, whereby the appellant oblique petitioner was sentenced to undergo rigorous imprisonment for life and also to pay a fine of rupees 20,000 for commission of offence punishable under section 302 IPC. Paragraph. The petitioner says that the entire case is based on circumstantial evidence. Stop. There is no eyewitness to the alleged incident of murder. Stop. There are various gaps and holes in the judgment under appeal. Stop. There is no certainty when the appeal will be heard. Stop. all along, he was on bail during the trial. Stop. He was only taken into custody on the day of pronouncement of judgment. Stop. He prays for bail pending disposal of the appeal. Paragraph. Opposing the prayer, comma, learned State Counsel says that the judgment under appeal is well reasoned and well informed. Stop. There may not have been any direct evidence, comma, however, comma, the chain of circumstances added up to come to the inevitable conclusion that it was the appellant who committed the murder. Stop. Circumstantial evidence can well be the basis of conviction. Stop. Bail should not be granted to the petitioner. Paragraph. We have considered the facts and circumstances of the case. Stop. We have seen the depositions of the witnesses examined before the learned trial court. Stop. It cannot be said that the appellant has no case to argue. Stop. There is no certainty as to when the appeal will be heard. Stop. The appeal is not even ready for hearing. Stop. The entire case is based on circumstantial evidence. Stop. Paragraph. We also find that the appellant all along, comma, throughout the trial, comma, enjoyed the privilege of bail. Stop. It is nobody's case that the appellant ever breached any condition of bail or misused the liberty of bail in any manner. Stop. Paragraph. In view of the above and on an overall assessment of the evidence on record and assimilation of the facts of the case, comma, we are inclined to and hereby do suspend the sentence and grant bail to the petitioner, comma, pending disposal of the appeal. The usual order, conditions. Your fine was stayed. When was it admitted? Which order is order? দেখতে পাচ্ছি না।
Page 91. Page 91.
Fine to stay করে দাও। We also stay the direction, stay the operation of the direction for payment of fine, comma, pending disposal of the appeal.
So 1 page later, this appeal was registered on the different 1 page later. So there is no formal appeal available on record.
Let him file a formal memo. Dispose of করার আগে. This is a jail appeal. Stop. Learned advocate for the appellant prays for leave to file a formal memorandum of appeal. Stop. Such leave is granted. এটা কত নম্বর হলো? 2 নম্বর না 3টে ডিসপোজার হলো। বাসুদেব বর্মন তো হয়ে গেল মোটামুটি অনেকগুলোই হয়ে গেল। 8
9
8 is not your matter. Union of India?
Superintendent of Police. Okay.
Lordship. Lordship, am I audible to your Lordship?
Yes, you are in 8. এই হচ্ছে problem virtually.
Application.
কি করে হবে এরকম ভাবে মামলা? We can't hear you, sir.
No, I'm not in the, I'm in item number 9.
Yes, 8, Mr. Mujumdar. What are the grounds? Yes, yes. Why should we grant you leave? This is what I'm asking. There's a delay. Grand 1 is condonation. Have you served the condonation? Condonation? So having been acquitted, he must have gone back. But then the fact, still you have to serve because after all, he has a right to oppose the condonation.
There cannot be any
You have to serve.
Our predicament is.
Through how? Through the embassy or whatever, we don't know. High Commission. Otherwise, it won't be fair. Won't be fair.
My lord, please answer.
Next circuit, we'll say next circuit. This is an application for leave to prefer appeal against an order of acquittal. Stop. There is also an application for, there is also a prayer for condonation of delay. Stop. Paragraph. The application should be served on the opposite party. Stop. Paragraph as requested by learned Deputy Solicitor General, comma, let this matter stand adjourned and be listed before the next available circuit bench. Stop. This is because, comma, the opposite party hails from Nepal and after acquittal, in all probability has gone back to his native country. Stop. Paragraph, let appropriate steps be taken for service on the opposite party. আর খুঁজেই পাবেন নেপাল চলে গেছে এখান থেকে পাচ্ছে তো গ্রামে গিয়ে বসে আছে কি খুঁজে পাবেন বাড়ি এখানেও তো আছে Yes.
Item 9.
Lordship, am I, now I'm audible to your Lordship?
Now, yes, you are a little audible, yes.
Lordship, may kindly, if possible, Lordship may kindly defer it to for on next Wednesday, if possible. I'll be appear in person. There are another appeal also
Much
there.
better, much better. You better come personally.
Lordship.
Very well. Have you effected service on your other side?
Lordship.
On the request made by learned advocate for the appellant, comma, let this matter stand adjourned and be listed again on April 9. You have not filed any application?
No, I have not filed.
Very well.
I have not filed.
All right. Next Wednesday, come.
Lordship, deeply obliged, Lordship.
For the respondent, state's appeal.
A state's appeal.
The pleadings are completely
What
For
is,
the writ petitioner.
Yes, I was for the report.
what is can 2?
for higher pay scale, I was granted below the higher scale of pay, but which has been challenged by the state.
What is can two?
Can, two below is for the state, application for state. One was from the condemnation of.
Who appeared? Mrs. Reena Sarkar, Mr. Bikash Shingo. You are appearing for the appellant. Yes. Let us see the judgment. Long judgment.
No, not that.
It was passed, in the absence of states, it was not different before the single.
State was not represented. Then go back before the learned judge.
Certain points we have to take.
We, as a matter of course, do not entertain when the appellant was absent before the learned single judge. Where is the খুঁজেই পাচ্ছি না তো judgment? ওই মেমো শেষের দিকে আছে। Mr. Ghosh, we are not entertaining this appeal. We are, if they want to approach a single judge, let them approach. Issue. This appeal is directed against a judgment and order dated January 22, 2021, passed by a learned judge of this court in WPA 329 of 2020, being a writ petition filed by the private respondents in this appeal. Stop. Paragraph. The writ petitioners had approached the learned single judge challenging a memo bearing number 11/C.C, and C stop C dutoi capital, dated November 3, 2016, by which the sorry, there was only one writ petitioner, no?
So one writ petition.
Oh, ওটা ভুল বলেছি, right petitioners বলেছি না? তাহলে he's হবে করে দিও তো। By which the petitioner's request for sanction of postgraduate scale of pay was rejected. Stop. The learned judge, by the impugned order, set aside the memo dated November 3, 2016, and directed the concerned state authorities to grant postgraduate scale of pay to the writ petitioner within a period of 4 weeks from the date of the judgment and not later than February 26, 2021. Stop. Paragraph. Being aggrieved, the District Inspector of Schools, Kuch Bihar, has come up by way of this appeal. Paragraph. At the outset, we notice that the respondents in the writ petition, including the present appellant, were not represented before the learned single judge. Stop. It is not that the writ petition was moved ex parte. Stop. In spite of notice, it appears that these state respondents were not present before the learned judge on the day the impugned order was passed. It is not your case that there was no notice. They served notice, you could not appear. Stop. Paragraph. Since the appellant was not before the learned single judge, chose not to be, the appellant chose not to be before the learned single judge on the day the writ petition was disposed of, we are not inclined to entertain this appeal. Stop. It will not be fair for us to entertain this appeal at the instance of a respondent in the writ petition who stayed away from the learned single judge. Paragraph. Hence, we dismiss this appeal without going into the merits of the case. Stop. Appeal and the connected application. Paragraph. This will not prevent the appellant from approaching the learned single judge with an appropriate application, if they are permitted to do so in law. They na karo, একটাই তো appellant. If he is permitted to do so in law.
That's all.
For the appellant. Your lordship, an earlier occasion had an occasion to deal with this appeal. Lordship, that by an order dated 11th of November, 12th of November 2024, this appeal was admitted.
Just allow us to go through the impugned order. That
Yes,
makes it easier for us.
Can application is also there.
Can for what?
Can for interim order also.
Order dated 24th September.
24th of September 2024, the impugned order.
Yes. Alternative remedy.
Alternative remedy on the ground of order, but I had already invoked upon prior to approach to the writ court, that has not been taken into consideration, and therefore.
Earlier, there was an order of the writ court.
Yes, sir.
Earlier, there was an order of the writ court.
Writ court has dismissed the writ petition only on the ground that I have not availed the
Alternative remedy,
but
yes.
I have already, I have, there is a record to show that I had already approached to the alternative remedy.
You must not have pointed that out to the
I
learned judge.
pointed out, but but the learned court below, the learned court below didn't entertain that you have simultaneously approached, that's why.
No, your alternative remedy application is pending before the
Yes,
authority.
still pending. No, they're still pending, but the thing is this is the commissioner and additional commissioner, the superior authority is the additional commissioner. This is the superior authority that I had already invoked upon.
And that is pending.
That is, they have not responded as yet.
We'll
Over the
direct
years,
them to dispose of that.
over the year.
We'll direct them within a time frame to dispose of that.
Lordship, that is one thing. So far the pendency of the concerned lordship, my humble, the so far plan is concerned lordship. Your lordship had directed, why admitted this appeal, had directed, kindly see that page at page 15 of my CAN application 2. Format. Pardon me. CAN 2, page 15.
What is CRAN 1 disposed of?
CAN 1 disposed of.
What was CRAN 1?
CRAN 1 interim order that was it was directed that the pendency of the appeal was not will not stand in the way for the authority to renewing the license of the appellant in accordance with law.
My lord, directed preparation of paperwork on the last occasion. My lord.
Paperwork has already been prepared.
Copy has been served upon.
So this is the copy of the paperwork.
Mr. Shahab, what we meant is that pendency of this will not stand in the way of you availing of any other remedy that you may have. If your appeal is pending before the appellate authority, we'll direct them to dispose of the, within a time frame.
True. Lordship, this
That is all.
No, my another, my.
We are not going to allow you to carry on business now without a license.
No, license, my, one whole submission only. During the pendency, during the original impugned order of suspension, the authority concerned has taken the renewal fees from mine. Despite acknowledging the renewal fees, they have not issued any renewal of license, and I'm still reopen my business. I'm still reopen my business. Pursuant to this, by this honorable court's direction, that is on 12th of 11/2024, I communicated this order to the concerned authority. The copy is attached herewith. Despite the same, they have not issued any formal renewal, and I am debarred to reopen my business. This is the whole difficulty till now. So my humble submission at this juncture, let the appeal authority decide my appeal, number one. Unless this is one thing, and immediately since I have already paid the renewal fees and renewal be issued, and I should reopen my business. This is my humble submission.
Take this plea before the appellate authority.
If they allow your appeal, then they will renew your license. Otherwise not. Esho. This appeal is directed against a judgment and order dated September 24, 2024, whereby a learned judge of this court disposed of court in effect dismissed the appellant's writ petition, being WPA 2047 of 2024. Paragraph. The appellant had approached the learned single judge challenging an order passed by the district magistrate and collector, Alipurduar, dated August 18, 2022, suspending the license of his restaurant cum bar. Stop. The learned judge noted that the order had been passed more than 2 years back, and there is an appellate forum available to the writ petitioner. Stop. The learned judge disposed of the writ petition by granting liberty to the writ petitioner to avail of the alternative remedy of appeal. Stop. Being aggrieved, the writ petitioner is before us by way of this appeal. Paragraph. Mr. Shaha, learned advocate appearing for the appellant, says that as on the date when the learned single judge passed the impugned order, the appellant's appeal before the statutory forum was already pending. Stop.
That is within bracket, it may be noted that the excise commissioner, government of West Bengal,
respondent
number
statutory forum বলেছি না নাকি বললাম ওটা ব্র্যাকেটে দিয়ে দাও ওই কি বললো
excise commissioner, government of West Bengal, respondent number 2.
Government of West Bengal.
By a letter, the appeal I have availed it by sending a notice, which is at page 63.
The appellate forum was moved by way of a notice dated. Notice না করে representation করো.
Representation.
Dated
20th of October 2022. 20th of October, sorry, 20th of August, sorry.
August 20, 2022.
It was acknowledged, fairly recorded, it was served upon them by a speed post dated same day, 22nd of August 2022. Which is available in page number 63.
Very well, very well.
Whole issue. This is
Stop.
This was addressed.
That was not considered by the learned single judge.
Magistrate and collector.
That was not considered by the learned single judge. Stop. The appellate authority should be directed to renew the license in favor of the writ petitioner, since renewal fees have already been received by them. Stop. Paragraph. We do not find any apparent infirmity in the order impugned before us. Stop. It may not have been submitted before the learned single judge that the writ petitioner has already approached the appellate forum available under the concerned statute.
Sees the representation, my lord.
Why?
It was not addressed to the appellate authority.
It was not.
No.
If it is not, it is not, then what can we do? We are dismissing the appeal. Stop. Cura? May not have been. Huh? Availed of the statutory remedy of appeal. Huh? Stop. Paragraph, be that as it may, comma, the appellant says that his representation oblique appeal is still pending before the competent authority. Stop. We direct that authority being the, again tell us, being excise,
Excise Commissioner,
or being the respondent number 2 herein.
respondent number 2.
Being the respondent number 2 herein, to dispose of such representation oblique,
Dated 20th of August 2022.
representation oblique appeal dated August 20, 2022, comma, in accordance with law, comma, by passing a reasoned order, comma, within a period of 4 weeks from the date of receipt of a copy of this order, comma, after granting an opportunity of hearing to the appellant herein or his authorized representative. Stop. The order so passed shall be communicated to the appellant within a week from the date of the order. Paragraph. In the event the competent authority, oblique appellate authority, allows the prayer of the present appellant, comma, it shall also consider the issue of renewal of the appellant's license in accordance with law. Huh? Paragraph disposed of.
Grateful.
Chaudhary said, what is it about him? How short? Anyway, pass to.
Lordship,
Short I will not grant. Ask for a long one, we'll give you.
appearing virtually, Lordship.
Passover practically means Mr. Panda, not today. Oh, Mr. Panda has come from Kolkata. Huh?
But in this matter, I beg to appear on behalf of the writ petitioner appellant before your lordship through virtual mode, my lord.
Yes.
Virtually.
Then why are you asking for time?
Section 5 has been allowed.
Make submission.
Appellant has submitted that the petitioner appeared for the post of assistant professor, which was initiated by the Withdrawal Police Service Commission, and he was the PWD B categories. But spite of there is a vacancy PWD A category, but the Police Service Commission did not recommend it in favor of the petitioner. But there is a mistake in the last order. The petitioner belongs to PWD B category. Wrongly it has been typed. I believe that.
Yes.
Now, the petitioner, the appellant.
Milord, I am for the petitioner appellant before your lordship, my lord.
1 second.
My lord.
Yes. Yes, Mr. Maiti.
My lord, I am placing my case, my lord. My lord, your lordship, on the other occasion, my lord, already.
No, we have already recorded your argument in our
My
order.
lord, your lordship. And
So let Mr.
on that
Panda
basis,
respond.
the argument has been recorded, but no document I produced before your lordship in favor of my client's, my lord, claim. Your lordship kindly allow me to place that, my lord. Thereafter, Mr. Banda will. If your lordship so pleases, my lord.
What document? তুমি সিএবি করে দিও কলকাতা গেলি তোমার কোনো be very brief and give us written notes. Written notes. Do you have written notes, Ms. Maiti?
No, my lord, I did not prepare.
Prepare written notes, come back on Tuesday, make very short submission and file
My
the
lord. Very short, my lord, but the notifications of government order, my lord, is required to be placed before your lordship on the next day, your lordship, so please.
Yes. Yes. Short submission.
Kindly see the first page 156. Which
Government order itself permits me to.
Kindly see, which by learned man as focusing that the petitioner is entitled by virtue of the clause 4, the petitioner would be recommended. But my lord, kindly see page 156, it was amended. But the kindly see 32 vacancy in the state notification reserved for scheduled caste person disability. The petitioner belongs to PWD B category. There is 4 category. It has been mentioned paragraph 2.
No, paragraph 4.
Paragraph 4. I am coming before
Yes.
that, madam.
Yes.
But the governor is further pleased to identify the below mentioned vacancies of model 100-point roster vacancy for the following type of benchmark disability to ensure that 1% each shall be reserved for the each type of benchmark disability. 12 vacancy unreserved person disability with blindness and low vision. B 32 vacancy scheduled caste person disability, locomotor disability including cerebral palsy, leprosy. These are particularly the 32 vacancy has been reserved. Then 42 unreserved, the rough and hard hearing and 72. Then kindly paragraph 3 is very important. If any of these vacancies cannot filled up due to non-availability of suitable person with benchmark disability or for any other sufficiency, such vacancy shall be filled up through the procedure mentioned in 34(2) of the Right to Person of Disability Act 2060. Well, kindly see the Disability Act page 173. 173. This is very important. So the section 34 reservation. There is 4 category of reservation. It has been mentioned. I am not reading. Now, kindly I am skipping that and kindly I'll come to directly 2. So where any recruitment year, any vacancy cannot be filled up due to non-availability of a suitable person with benchmark disability or for any other sufficiency, such vacancies shall be carried forward in the succeeding recruitment year. And if the succeeding recruitment year also suitable person with benchmark disability is not available, it may be first filled up by interchanging of the 5 category, and only when there is no person with disability available for the post in that year, the employer shall be
fill up the vacancy, appointment of person other than disability. Other than disability. Then, my lord, kindly, again, my lord, kindly, I am requesting people, lordship, kindly come to page 156. While understand hammering and my lord, the placing that clause 4, no curtailment of existing percentage reservation of scheduled caste can be made in this regard. Hence, if no suitable SC candidate with benchmark disability is available for filling up 32 vacancy, then the said vacancy will be first be filled up by the SC candidate with other benchmark disability by interchanging amongst the category as mentioned in para 2A, C and D with explicit and prior permission of the appropriate government. If there is no person with disability available for the relevant vacancy in that year, the employer then only shall be filled up vacancy by the appointment of a SC person without any disability with approval of the appropriate government. Now, my lord, my learned friend or senior learned friend was pressing for paragraph, my lord, asking for the filling of the vacancy which is not been filled up due to non-ability. That is for unreserved. This is not the scheduled caste. My lord, kindly see now vacancy list. Now, kindly see the vacancy. Here, my lord, vacancy list. My lord, kindly see the panel, page 30. Page 30, 130.
Page?
130. Page 130 is the panel map.
Yes.
My lord, kindly see category PWDA. PWDA, my lord, this is unreserved for my lord, the low vision, blindness and low vision. My lord, there is a 3 vacancy was notified. My lord, the out of 3 vacancy, my lord, the 6 person which was my lord, empanel. My lord, the first empanel candidate, Orijit Chakraborty, absent in the counseling. Then my lord, the second empanel candidate has been recommended Mecklenburg College. Then my lord, third candidate recommended, despite recommendation, did not join. Then my lord, the fourth candidate was called for, my lord, the recommendation in the Chitra College, he has my lord got. And the fifth and sixth, out of my lord, the 1 vacancy, which was my lord left out due to non-filling of the vacancy, the fifth candidate also first my lord, called for counseling, despite recommendation, he did not join. Then my lord, 6th candidate has been my lord offered. He my lord, despite offering, he absent. Now this post has been filled up. Now the petitioner is the serial number 2. This is one of the PWDB in respect of one of scheduled caste and one of the locomotor. The petitioner now asking for PWDA category, which is to be filled up by virtue of 34(2). So my lord, the petitioner cannot claim that he would be an unreserved candidate.
এটা অফ আছে তো মেইল বাকিটা চলছে না না হয়তো মেইল বাকিটা না 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 অফ কিনা দেখো অফ আছে অফ করতে চাইছি That is all. We have followed, Mr. Panda. You file your notes. So you need not, yes, you need not come back on Tuesday.
I can,
Virtually.
and one, my lord, firstly, I am not the appropriate authority. Appropriate authority is the government. I am only for recommending unless the requisition has been.
You are the inappropriate authority. If you are not appropriate, you are inappropriate.
Conversion of, I am not a
Direction is upon you,
no,
upon the appropriate authority.
appropriate. Here, the petitioners, the appellants, contention list, the College Service Commission has prepared as one of the panel. Unless his name has been recommended in the PWDA category, the College Service Commission will not be issue the recommendation.
Acha, lekho. Heard learned counsel for the parties at some length. Stop. Mr. Panda, learned advocate appearing for the West Bengal College Service Commission, concludes his argument and also files short written notes of arguments. Paragraph, Mrs. Maiti, learned advocate appearing for the appellant, has also made her submission, but seeks leave to make very short oral submission on the next date and file her client's written note of argument. Paragraph, list the matter once again, Mongolbarer date diye dao, Mongolbarer date, retaining its position.
Date fully published.
There is a mistake, PWD, A category, the petitioner, it would be PWD, the petitioner belongs to PWD, B category.
Be it noted that in the order dated April 2, 2025, an error has crept in inadvertently. Stop. Although in paragraph 5 of the order, it is recorded that the appellant / writ petitioner is a person with disability, capital A, dash PWD bracket capital A bracket closed category, in fact, he is a person with disability dash PWD bracket capital B category.
As your lordship, deeply obliged to your lordship.
Yes.
If doctor fixed on Monday, then I can still.
I beg to appear.
Still showing defective. Why?
Defective has been removed. Only one word was.
No. Yes.
Lordship, in this matter.
Let us read the order first.
Yes.
That is what we do normally. The impugned order is dated 13th February 2025. Who has filed the appeal? Rita and Rintu.
Yes, Lordship. Number of civil suits are pending. In both the suits, injunction order is there. Against this particular inaction, the private respondent has filed the writ application against me, although I am not the parties in the civil suit initially.
After institution of the suit and during pendency of the suit, I have been imputed as the parties therein. Thereafter, no summon has been served upon that. It was no knowledge regarding that institution of the suit, even also injunction order. And in spite of suppression of all these material facts, I am the owner, and what the case has been filed by the private respondent, I annex the document, Lordship, page number 42. This is the suit for the recovery of possession.
Is there any order of injunction upon you?
Order of injunction has been passed against me, but at that time I was not present in the court. As because no amended plaint has been filed and no summon has been served upon the defendants at the relevant time. The
Sir,
entire proceeding was beyond my knowledge.
please go and ask for vacating then.
I already filed the application. Suomoto appeared before the court and stated all the irregularities regarding the. But the thing is that operating part of the last portion that is giving me the trouble. Lord.
We will clarify that your vacating petition will be decided by the learned trial court without being influenced by anything in this High Court's order or in our order that we'll pass.
Yes, Lordship. But the thing is that the police is giving me the lots of trouble with the collusion of the private.
No, so long as the order of the civil court remains, the police may give you trouble. Have that vacated.
Yes. We are just complying the order.
Have it vacated.
Lordship, pass the necessary order. Give me the necessary direction
Yes.
upon the lower court bill.
Have it vacated.
I have no problem.
Yes. Esho.
Admittedly, this is the suit for the recovery position. Admittedly, I am in the possession. And thereafter, this suit has been filed. I am the registered owner by virtue of the registered sale deed. I have been given the bank loan for constructing the house building thereon.
Very well. This appeal is directed against a judgment and order dated February 13, 2025, whereby a learned judge of this court disposed of a writ petition of the respondent number 1 in this appeal, being WPA 359 of 2025. Stop. Paragraph. The writ petitioner approached the learned single judge with a prayer for an appropriate direction on the police authorities to implement an order of status quo that the writ petitioner claims to have obtained in respect of the concerned property in title suit number 138 of 2022, pending in the court of the learned civil judge, bracketed junior division, bracket closed, Jalpaiguri, on March 5, 2024. So, he alleged that in spite of the order of status quo, the respondent numbers 4 to 6 in the writ petition, bracketed likho, the present appellants being the respondent numbers 4 and 5 in the writ petition,
yes,
bracket closed, were continuing with construction work on the suit premises. Stop. The learned judge paragraph. The learned judge disposed of the writ petition with the following directions. Bracket করে দিচ্ছি। হ্যাঁ, তোমার মেমোর সঙ্গে অ্যানেক্স করা আছে ইমপিউন্ড অর্ডারটা, এই পোস্ট-ইট মেরে দিলাম। Paragraph. Being aggrieved, the respondent numbers 4 and 5 in the writ petition have come up by way of this appeal. Paragraph. Learned advocate for the appellants says that the interim order was the interim order of status quo was obtained. You were added subsequently.
Subsequently, but no summon has been served.
No, but you were not a party as on March 5, 2024. That you wouldn't know. You say may have been made a
After
party.
getting the copy of the writ petition, I got that.
At the without notice to the appellants herein, and the appellants are not even sure if on that date, i.e. March 5, 2024, the appellants had been included as party defendants to title suit number 138 of 2022. So the appellants say that they are that originally they were not party defendants to that suit.
As per the plaintiff.
As per the copy of the plaint served on them.
The writ application, with the writ application.
As a copy of the plaint annexed to the writ petition. So, till date, no copy of any amended plaint or writ of summons has been served on the present appellants in connection with the aforesaid title suit. Stop. Paragraph. The appellants further say that they have already applied for vacating of the interim order of status quo. Stop. The appellants are in possession of the suit property and are owners thereof by way of registered
Sale deed and the
sale deed,
certificate. Yeah.
as well as mutation certificate. Stop. However, because of the order of the learned single judge, the concerned police authorities are making life very difficult for the appellants. Paragraph. We have also heard learned advocates for the parties, other parties. Stop. Paragraph. We cannot find any fault with the learned single judge's order. Stop. We do not cannot do. The learned judge was perfectly justified in observing that once a competent civil court has issued an injunction order, it should be carried out by all concerned. Stop. Paragraph. However, we are told that the appellants herein have now approached the learned trial court in title suit number 138 of 2022 for having the interim order of status quo vacated. Stop. We direct the learned trial court to dispose of such application request. We have no idea it could be authority as we request the learned trial court to dispose of that application filed by the appellants herein as soon as possible and preferably within 3 months.
1 month. 1 month.
No. You have no idea under what pressure they work. 3 months from the date of communication of this order, without being influenced by any observation in the order dated February 13, 2025, passed by the learned single judge in WPA 359 of 2025, or any observation in the present order. Stop. The learned trial court shall decide the application for vacating the interim order independently and in accordance with law.
Slightest of indulgence. The state authority has acted and in compliance with the order passed by the honorable court.
We acted যেখানে we have heard we have heard learned advocates for the other parties talk. Learned state advocate says that the police authorities have acted strictly in terms of the order of the learned single judge and have not in any manner inconvenienced the present appellants.
One line, also, since no affidavit call for, so it not be admitted.
Paragraph, since we have not called for affidavits, the allegations made in the stay petition are deemed not to be admitted by the respondents. Appeal and connected application disposed of. Oh, পঁচিশে না? That next year, Dr.
It's item 15, my lords. I'm praying for Wednesday, my lords.
For
Wednesday, I'm praying for Wednesday, my lords.
Wednesday?
Yes.
Why?
And there are certain judgments, my lords, that needs to be placed.
Wednesday?
Wednesday.
And for the appellants. Well, in this matter, it's a similar matter. Lordships has passed an order. All the facts are the same. The order is also the same of the lower court. The only difference is that in that case, madam, the land was owned by the plaintiff company. Here it is owned by in the name of the directors of the plaintiff.
Name of?
Directors of the plaintiff company.
What was the order?
Madam.
I can't remember what happened 1 hour before, and you are telling me that order, that matter, that order.
Well, I have brought that. Is an appeal from the.
Here also there's a
refusal of
delay.
status.
Here also there's a delay in this matter.
Yes, same day, same 26 days.
Here it will be the plaintiffs.
Plaintiffs. That was the plaintiff company. It was in the part of the land in the same plots or purchased in the name of the company, and this was a purchase.
So that is the only change in this
That is
order.
nothing.
Plaintiff and plaintiffs.
Plaintiffs.
এই অর্ডারটাই হবে ওইগুলো নাম্বার নাম ফাম বদলে দিও সব কস্ট টাইটেল ওরকম করছো কেন একটু মাথা নাড়ানো এরকম করেছি বুঝতে পেরেছি বুঝি এখানে প্লেন্টিফ ছিল একটা এটা খালি প্লেন্টিফস হবে যেখানে যেখানে প্লেন্টিফ কথাটা আছে
Grateful. For an affidavit of service. Affidavit.
Why is it showing defective again? Yeah, this matter.
Delay.
Oh,
Delay.
আগে তোমার ডিলেটা ঠিক যা ছিল ওই অর্ডারটায় Yes, we will rise now because I have to come back. You want to mention something?
My lord, sorry, my lord,
Well,
I draw my lord's kind attention. My
But
lord.
item 17
Yes.
was a substitution application.
17.
The appellate number 3 has died. Along with section 5.
Very well.
Copy of the
Tomorrow,
application.
Mr. Bhattacharjee, on Monday. We have
On
to
Monday?
write. Yes.
Oh, yes.
Last
I
matter,
know what. Okay.
where Mr. Kundu was appearing, my lord, was a matter. My name, my lord, has brought to these orders, my lord.
No,
I did not appear, my lord.
No, correct.
It is,
Hey.
At the practice, my lord, someone gives name, which at my instance, the LR has issued a notification. The person who is not appearing, name should not be given. So, my lord, this should be very complicated, my lord. The moment it has brought to my.
এক্ষুনি করে দাও mentioning it.
My lord,
কে করেছে এটা কার বলো তো?
Definitely, someone has given name. That's why the Lordship's court officer has done it. It is not that Somot has come.
ও খুলে করে দিতে পারবে না এমনি অর্ডার দিতে হবে
My lord, it has been published, uploaded.
Very well. আচ্ছা করে দাও এই কস্ট টাইটেল নিয়ে যেটা আছে this matter has been mentioned by learned additional advocate general. Stop. Let this matter be treated as on days list. Paragraph. On April 3, 2025, when this matter was taken up for hearing, learned AAG was on the virtual mode, but he was not appearing in this matter.
But for other matters, my lord.
Virtual mode for other matters, but he was not appearing in this matter. In these matters, একাধিক appeal আছে. Stop. However, by virtue of his office, comma, I had informally asked him certain things which he had clarified. Stop. His name has been wrongly appearing in this, in the order dated April 3, 2025. Stop. His name should stand deleted from the list of appearing counsel in the order dated April 3, 2025. Paragraph. Let this correction be incorporated in the order dated April 3. বুঝতে পেরেছো কি ব্যাপারটা? বড় কিছুই নয়, এটা করে দাও।
Lord, I follow, my lord, and this is my instruction to all my juniors. You should not. And at my instance, my lord, the LR has issued the notification. The supplementary list, we are publishing a supplementary list. Unless it is listed, server cannot be made, they say. For a correction, acha, oh, supplementary list karta. Yes, ma'am. Yes, yes, yes. Baro call kore the supplementary list ekta. For correction. Grateful. I'll come back for 1 minute only. It's virtually a consent order because the respondent who appeared in person, he also said they appoint an arbitrator.
Yes.
It's just that he will not agree to any name that you will suggest.
Yes.
That's what happens between brothers. I've appointed Sri Pritam Roy, advocate. Phone number is also here. And he'll be entitled to take the assistance of a chartered accountant in case he requires it. Hmm? That's all. Hey, কি করবে এটা সার্ভার করে দাও। All right.